The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
You may be seated. Thank you. Ms. Lyston?
Chief Judge Gregory, and may it please the court, Jenny Lyston for Roger Locklear. Your Honors, we are asking you to vacate as procedurally or substantively unreasonable a special condition of supervised release requiring Mr. Locklear to submit to broad warrantless searches. This search condition is found at JA 109. It requires Mr. Locklear to submit to a search at any time, with or without a warrant, and by any law enforcement or probation officer of not just his person and property, but also his house, residence, vehicle, papers, computer, other electronic communication or data storage devices or media and effects. Your Honors, the search condition is procedurally unreasonable because the district court's explanation, very brief explanation for this intrusive condition, was insufficient to explain why this particular condition was needed in this particular circumstance. I would like to note that for purposes of today's argument, while we are not conceding that plain error applies, I am simply assuming that plain error applies, and I am happy to do so because I believe that we win under either standard. What little the court said here was either vague or unsupported by the record. The court's explanation of all of the conditions, not just the search condition, but all of the special conditions imposed in this case, is found at JA 100. And what the court said was that he was imposing these special conditions based on the statutory requirements and the nature of the offense of conviction, including your history of substance abuse, the need for rehabilitation in order to supervise you adequately.
Well, but hadn't he previously gone through the fact that Mr. Locklear was essentially a drug dealer and a violent one at that, and raised all kinds of threats to people who encountered him and society in general?
Absolutely, Your Honor. In explaining the sentence as a whole, the district court certainly cited Mr. Locklear's criminal history and history of drug dealing. However, I don't think that that explains why, for example, the probation officer would need to search Mr. Locklear's computer or his cell phone, which, as the Supreme Court has said, contains the most intimate details of someone's life.
Including their proposed drug transactions.
So, Your Honor, there was nothing in the record to show that Mr. Locklear used a cell phone for any of his drug transactions. In fact, if you'll look in
Well,
JA...
but didn't the judge, I think as a district judge, I'm aware that drug dealers everywhere use their cell phones to make drug transactions.
And yet, notably, Your Honor, in JA 116, it talks about how after this kind of drug deal went down and went wrong, and they were both shot, they actually, one of the drug dealers had to go to a convenience store to call for an ambulance because apparently he didn't have a cell phone. And also, Mr. Locklear's friend approached I think it was an emergency department services. They didn't call. So there was no evidence that they were using a cell phone. But even if they were, again, a search of his computer seems well outside any sort of necessary condition that you would need to.
Well, why wouldn't you wait for you're attacking this condition facially? Why wouldn't you wait for an as-applied challenge if you think the search exceeded the proper bounds? But this is just, what you want to do is just invalidate the special condition in toto.
No, Your Honor, that's not what I'm saying. I'm saying that this particular warrantless search condition was not individualized to Mr. Locklear's circumstances. I'm not saying that perhaps if it went back, the district court might...
Why wouldn't it be individualized, given the violence that attended the instant offense, and given the record of prior offenses, which were involved violence and assault with a deadly weapon and inflicting serious injuries, and that's on 2 different occasions, and that's just for starters. The prison record showed fighting and the like, and you just have a situation confronting the district judge where he's thinking, I've got to do something to protect the probation officer and to protect the public. And that's right in line with what the 3553A factors show and the way in which they apply to supervised release. I mean, it almost seemed like it would be irresponsible of the district judge not to impose the special condition.
So, Your Honor, I'm not saying that the district court could not impose a warrantless search condition. I'm saying that this particular warrantless search condition far exceeds what is necessary to, as you say, protect the public and to ensure that the probation officer can adequately supervise Mr. Locklear, because it simply doesn't make any sense that they would need to, for example, search his computer. That's something that we impose, that the Sentencing Commission recommends for sex offenders.
I know, but that's tempered in an extent, because there has to be some reasonable suspicion. You can't just charge in, and there has to be reasonable suspicion that drugs and firearms are involved before you can undertake the search at all.
Well, I think what the condition imposes is that as long as this probation officer has any suspicion of any sort of violation, that he can do the search of everything. I think that's what this search allows. And again, I simply don't see that there is anything in this record that shows that the court, one, really gave an individualized consideration of this search condition to Mr. Locklear's case.
We're living in a modern world, and in this contemporary world, as Judge Gibney pointed out, cell phones are used to effectuate and implement drug deals, and computers can be of assistance to that as well. It almost seems to deny the value of technology to say, well, you can't do this, you can't do that, when that might contain very probative evidence of a violation.
So I think to the extent that all of us, every one of us, uses a cell phone every day for everything, absolutely, there's a theoretical chance that there might be something on the cell phone, but notably, the Sentencing Commission doesn't recommend that we impose a warrantless search condition for just everyone. I mean, if that were the case, everyone would get this warrantless search condition where you could search the phone, of anyone. But it is only recommended for sex offenders, and it's probably because, notably, in most cases, sex offenders use a computer or a cell phone as an instrumentality of the crime. As this court said in Arbaugh, a warrantless search condition for a computer or a cell phone is something you really do need to think about. In Arbaugh, the defendant was actually convicted of molesting children in Haiti, and yet this court said that after the court imposed that warrantless search condition on the computer and cell phone, because in that case there was no evidence the defendant had used a computer or cell phone in the crime, this court said that, and the court gave no explanation for imposing that. This court said that was erroneous, and that needed to go back for a further exploration. And that's what we're asking for in this case, Your Honor. We'd like for this to go back, and I think if the district court actually takes a careful look at this condition and has to articulate the reasons for why it feels that, the probation officer needs to be able to search Mr. Locklear's cell phone or his computer, then I don't think that the district court would reimpose that
Well, why
condition.
don't you wait until the computer's actually searched? Because there can be all kinds of searches based on reasonable suspicion where the search would not touch the computer or involve the computer at all. But then there may be others in which the computer could have been involved in the criminal activity. And I just don't understand why a facial challenge isn't premature.
So again, Your Honor, I don't see this as us bringing a facial challenge to the search, to the condition itself. We're simply saying that it was not individualized, as these court's decisions require, to Mr. Locklear. We also think that it's substantively unreasonable because it involves a greater deprivation of liberty than is reasonably necessary to achieve the purposes of adequately supervising Mr. Locklear.
Do you think the judge has to make some sort of separate pronouncement of the reasons for his sentence for everything that's in the conditions of supervised release?
So for special conditions, Your Honor, this court has said that the court, yes, in Arbaugh, it said it needs to put on the record, explain what facts led it to the conclusion that the probation officer needs the ability, for example, to search Mr. Locklear's computer. And also, I would just, getting back to what the court in this case actually said. So sort of breaking that down, the first thing he said, it was based on statutory requirements.
Well, but don't forget all these other things he said was he was going through his explanation of the sentence. It's not like this happened in a vacuum.
No, absolutely, Your Honor. And, but again, I don't think anything that the court said really truly explains what facts led it to the conclusion that this particular search condition, this very expansive search condition, which, by the way, is different from the search condition that was imposed the first time around, why it's necessary now at resentencing to impose this much broader search condition on Mr. Locklear.
One concern I have generally is that when we sort of chomp down, I mean, district courts are allowed a broad degree of discretion in setting conditions for supervised release. And if we start getting too fine-grained on this and picking at the finer details of this condition or that condition, do we undermine the utility of supervised release as a tool of punishment? Because the district court, I mean, supervised release represents a very salutary development in that it gives an offender the chance and the opportunity to get out of prison and to make a life for himself or for herself under supervised conditions. But it's a sort of a re-entry gateway, and I think it's a good idea, but if we start chomping down on this too vigorously, I worry district courts would say, well, we're just going to sentence to a greater degree rather than rely on supervised release as a tool because this and that is going to be picked apart. So I wonder whether we are undermining supervised release as a component of criminal sentencing.
So, Your Honor, I don't think that what we're asking is very difficult for the district court to comply with. We're only asking that it follow this court's decisions, what this court has said, that when you are imposing, the Sentencing Commission recommends certain conditions for certain categories of offenders, and obviously this warrantless search condition is recommended for sex offenders. We're simply saying that if you're going to go, and we're not saying that you can't impose this warrantless search condition if it applies in individual cases, but we're simply saying that if you're going to go outside the norm and apply this in a, just in a regular case, you just need to put on the record some reasons
Well,
that
of
support
course,
that.
I mean, of course, the fact that it may have a special utility in sex offender cases doesn't mean that it's somehow that it's somehow prohibited in other classifications.
Absolutely, Your Honor, and that's why I said we're not saying that you couldn't apply it in appropriate circumstances, but when you do it, you need to put on the record reasons that are supported by the record to show that you have actually thought about this condition and have individualized it to the circumstances of the case.
So if we send it back, if the judge had said in this case, well, this gentleman is violent, he deals in drugs, and I know that drug dealers use phones, and I know that drug dealers use computers, and I know that drug dealers pose threats to probation officers. So I'm going to impose this condition. Would that be enough?
I think without any evidence in the record, especially of the computer, I think I would have a hard time. I simply don't think there's any evidence to apply it to a search of Mr. Locklear's computer in this case. Whether or not we can get to the phone is another matter. But as I said, Judge Gibney, if this goes back, I think that if this goes back and the district court is required to put on the record the reasons supported by the record that why a search of the computer and the cell phone would be needed here, I think the district court would probably say, actually, the first warrantless search condition that we had is fine and adequate, and I don't think it needs to be expanded. I think the court just sort of, slapped on this, took this sort of warrantless search condition wholesale out of the Sentencing Commission's guidelines and slapped it in there and didn't really think about it. I see my time has expired. I will see you at rebuttal. Thank you.
Thank you, Ms. Lyson. Ms. Fritz.
Good morning. May it please the court, Christine Fritz on behalf of the United States. We're asking you to affirm the judgment of the district court. This warrantless
Could you
search-
move the microphone a little bit closer? Thank you.
Is that better?
Yeah, that'll be better. Thank you.
You're welcome. This warrantless search condition was procedurally and substantively reasonable, and it should be affirmed. Briefly, I'd like to address the standard of review issue. The government maintains that this should be reviewed under a plain error standard of review. When you look at the record and the arguments that were presented by defense counsel and by the defendant himself, there's nothing. The defendant and counsel requested a more lenient sentence. They argued that a top of the guideline sentence was excessive in light of the 3553A factors. And then the defendant requested leniency and proposed different aspects of his post-release or his post-conviction, post-sentencing conduct in support of that. Nothing about that request would fairly alert the district court that there is a concern about the warrantless search condition. In some of the absence of evidence of, for example, use of a cell phone or use of a computer or other social media or messaging app that might be on a computer and a cell phone, the absence of that is in part because this concern was not brought to the district court's attention. So under LBAS, we think, and this court's prior precedent, which talks about the objection needing to be made with specific or sufficient specificity to reasonably alert the court to the true concerns, that this has to be reviewed under plain error. And under plain error, what the district court said is sufficient here.
How does your position square with Arbaugh?
With Arbaugh,
Yes. I mean, the Fourth Circuit has spoken plainly, even in cases where this special condition is used a lot in terms of dealing with sex, and with children and those things, we reversed them because they didn't do these type things here. This is on this continuum, less focused than computers. But then those that we say that are related to computers, we say it's not sufficient. I mean, I want you to distinguish Arbaugh, because that's our precedent in the Fourth Circuit. Distinguish that, please.
so I think that there were multiple conditions in place at Arbaugh, and that it wasn't.
There were.
There
but
were,
Focus on the ones that we, on that basis, that we remanded it.
Yes, and I think that one of the conditions that I thought was most concerning to the district court was,
The district court, I'm talking about
I'm
the
sorry,
Fourth
to the
Circuit.
appellate court, was,
Yeah, this court right here.
this court, was the ban on the access to the internet. It was more generally related to computers, that the defendant's conduct was limited and banned.
But you could easily say, well, if it's dealing with child pornography, it's a no-brainer. Computers is sufficient. But we didn't say that, did we?
No.
And likewise here, how do you, it seems, is your argument because drug dealers use computers, then you can always do this for a drug dealer, right?
No, Your Honor.
Why not? What were the things? What kind of drug dealers don't have to have this? How do we distinguish? Demographics or what? What is it?
Well, first, I think that I would separate slightly the distinction between the search of the residence, his person, his home, the search for items.
We're talking about computers right now.
And I think that if this court is concerned about the adequacy of the explanation as solely as to computers, I agree that there is not as much in the record
As
addressing
much?
it.
There's none.
Other than that the condition was imposed, yes. And that there was no concern brought to the court's attention.
That's why, well, counsel said that she believes that plain error is surmounted here. So let's deal with proposing that is plain error.
Well, under the plain error, I think that first, Your Honor, would look at the warrantless search condition generally, and then I would like to turn and focus on the computer issue, with Your Honor's permission.
No. It's a colloquy, but right now it's a question. I'm talking about computers. Let's focus on computers. What's the basis for? I'm just asking you, is it because there's drug dealing, that means it's automatically sufficient because we can assume that drug dealing? I think people involved in security fraud too use computers in a great deal, probably even more.
They do. I think that here.
Don't they? Do they get this, you think? We could put that in theirs too? All of them?
I'm not saying that for every drug dealer or every fraudster that you automatically get a particular
So
condition.
it has to be individualized, doesn't it?
And I think that this entire sentencing.
No, it has to be individualized, correct?
Correct.
So what's the individual aspects of computers with this record, with this person?
With this individual, the court provided another tool for the probation officer to effectively discharge his supervisory duties.
Is that the standard of our box? Okay, this is sufficient because that's a tool. As long as it's a tool for the probation, is that the metric? Counsel, I started with, I want you to distinguish Arbaugh, and you haven't done that yet. But, you know, I'm trying, we're not talking about a toolbox for, I'm sure a lot of things, you know, a lot of tools you would want in probation, but that's not the question. We're talking about computers. That's why I want to focus on that.
And I acknowledge that the district court did not specifically address computers.
Nor does the record give support for that condition, correct?
Correct.
All right.
And that is in part, I think, because there was no objection.
That's why we're on plain error. Okay.
Exactly.
But still, whose responsibility it is to give a proper sentence?
It's the court's responsibility to give a proper sentence, and we
Right.
submit that he did so here.
Well, Fourth Amendment is pretty plain. Arbaugh, you haven't distinguished it yet.
And I am sorry that
So we can't just ignore the Fourth Circuit.
No, I am not attempting to do that at all. I think that Arbaugh is distinguishable in various ways.
That's what I'm waiting
in terms
for.
of, first of all, those conditions were lifetime conditions of supervised release related to computers. The offense did not involve computers. It was a sex offense, but it did not involve computers because it was the
Is that a distinguishing factor here? This crime didn't involve computers, did it?
I think in addition, though.
Did it?
Not to my knowledge, not on the record.
No,
But
okay.
furthermore, the conditions in Arbaugh actually restricted or changed the defendant's conduct. Here, we have a condition that lessens the defendant's reasonable expectation of privacy.
One of the differences in this case and others, I think, in the ones where we've been particularly concerned about computers. They've been special conditions or what have you, where the person was prohibited from using the computer at all. And we're saying you cannot use the computer in any way, shape, or fashion. And often because it was utilized to ensnare victims or to lure victims or what have you. But in this instance, there's no prohibition on the use of the computer. If this individual wants to use the computer to enhance his job prospects in some way, shape, or form, he can do that, as I understand it. It's not a prohibition on use. It's simply a recognition of the everyday fact that a computer could be used to set up or facilitate a drug deal in some way, shape, or form. But there is a distinction, it seems to me, between a special condition that prohibits use and a special condition that says if we have reasonable suspicion the drugs or firearms are involved in some way, then you can look into it. I mean, the computers have all sorts of email information that is exchanged in one way or another. And it is the computer, as well as the cell phone, is a device which is utilized for communication. And communication can be essential to the operation of a drug operation. I just see that there's a difference, I think, between prohibitions on use and allowance of use. You see what I'm saying?
Yes, I do, and I was trying to articulate that, perhaps not as,
So are you incorporating Judge Wilkinson's argument to yours? Is that your argument?
I am, but I'm,
Okay, well, let me deal with your argument since you incorporated it. I can't question my dear friend, I can question you. Just make sure you incorporate it. But tell me, again, it goes back to computers. Everything we said about computers applies to almost every crime, particularly securities fraud, right? These things have, emails are important to see whether or not you're involved in something else. Let's see, if you pass bad checks, emails will be helpful to see whether or not you're making communications with other lending companies. What else is there? Let me see, if you're a shoplifter, see whether or not you're going back online and try to purchase things fraudulently. I just cannot imagine any limitation on a computer's use and facility, as you said so well, being a tool for the probation. But that's not the law in the Fourth Circuit.
and I think that I would direct the court's attention to the actual terms of the condition, which is, first of all,
I think I've read them.
it would be, for a law enforcement officer to conduct the search, reasonable suspicion would be needed. For a probation officer to conduct the search, it would need to be the lawful discharge of the duties. And again, the probation officer does hold a unique position in that he's not he's not a typical law enforcement officer who's attempting to ferret out criminal conduct. Rather, he's attempting to assist the defendant in his transition to the community. That is a primary goal of every probation officer, to assist the defendant with his transition. And if the officer believes that in the lawful discharge of his duties that a search might be appropriate, that is a reasonable thing for the district court to do in a situation like this, where the defendant has a terrible criminal record, a history of disobeying rules, whether on probation, post-release supervision, incarcerated. He has a significant history of drug dealing, possession of firearms illegally, discharge of firearms illegally. And the court recognized that concern and crafted a warrantless search condition that it thought would appropriately address this concern. And I think that, and I would point out that unlike the other conditions that are often considered, especially in the sex offender cases, this doesn't limit the defendant's conduct. He's still able to have the computer.
It does limit are you telling me, for example, you're saying that if I can go into your computer on a warrantless basis, that doesn't limit my use of computers?
No,
It doesn't? If you knew that somebody could go in there and look at everything you're putting on your computer, your personal computer, and all they need is their suspicion, that wouldn't limit your use?
they would need reasonable suspicion.
No,
or-
not reasonable, but suspicion. Like you said, probation officer.
And I think this also comes down to, though,
But let's
that
go back to what you said. Are you telling me that wouldn't limit your use of a computer? I mean, just common sense, would it? Wouldn't?
I don't think it would.
Oh, my goodness.
I mean, insofar as it might limit the use of a computer by deterring somebody
So
from.
everything in your computer, you
using-
wouldn't mind anybody reading it, right?
I think that I have a different expectation of privacy than somebody who's on supervised release.
Oh, I see.
And-
But we're
and-
talking about now computers and limiting access. Now you're going to say, well, I'm different than him. I'm not him. But what we're talking about
Well-
is what a computer, in terms of what you're saying would be no limit. Every crime you could do that. Won't you at least concede that? Every crime, the computer could be attached to that potential similar conduct they were convicted of. Again, correct? What, can you think of a crime that a computer wouldn't aid?
I'm sure there are crimes that a computer wouldn't aid.
You can't think of one, because every one you bring up, I think I could shoot it down. Even if you're
Lying
strong
to a
arms,
federal firearms dealer.
lying to
To
a,
a federal firearms dealer on a form. Unlawfully obtaining a firearm by lying to a federal firearms
well, you
dealer.
can go on the computer and see whether or not, how liberal people are in terms of selling guns. You can shop around in terms of what dealers come. They're different. All of them not the same. You know, in a computer, you can say, who are the people that turn the blind eye to straw purchases or those type things? That's why it's a computer. It's taking over all of us. And that's why it's so important. And the question is this. The Supreme Court has told us in Rogers that these things are important. And even when you give a condition, they're not present. We said, oh, you got to go back and do it again because the Supreme Court said that's important. Statistics will show the way you set people up. I don't mean that intentionally, but the conditions you can show in terms of averages or likelihood of whether or not you're going to be violated. The more ornaments you put on it, the easier it is. Like even being able to get someplace. People who can't drive, don't have a car. Well, you got to make sure that if you miss that appointment, you violate. Well, that's going to fall harder on people. This is an important part. And my good friend said this is a time of rehabilitation, but the things you put in there have a big impact on whether or not they're going to be successful. And I've never seen these kind of things with security fraud and all those things because they're chalked with computer. And justice is about fairness, isn't it? Especially with Arbaugh telling us this is not a secret. This is important. These are important things. They have to be individualized because otherwise you'd be back here, not you, but the same argument, well, we did it here. In this case, Locklear, it didn't say anything about computers at all. So it would be an open range. An open range. And there's no limit at all. That's why I'm trying to get you to give me a limit about computers. Warrantless search by suspicion by the probation officer. And just saying, well, I suspect that you might be, I saw you sniffing the other day, and there might be some signs that you're using cocaine. Oh, really? But I thought the whole purpose is because of drug dealing and using drugs. That's the connector.
And
isn't
if
it?
the officers had reasonable suspicion that the cellular telephones or that the computer were being used to facilitate the drug transaction, yes, I think the
You're putting a
condition would
lot of
permit that.
ornamentation on something that's not in there at all. Those limitations are not there. That's why in Arbaugh we said it has to be individualized, because otherwise you can say, well, we in good faith, we know you wouldn't use it without reasonable suspicion. No. You know, the world construes by wit, but the court must construe by the law, as was said in The Man for All Seasons.
Your Honor, to the extent that this discussion has been primarily about the computer, and if this court wanted to, I think that you could strike that portion of the condition, but I don't think that the entire warrantless search condition needs to fail.
Why don't you know, one of the things is you just need to go back to your main point, and that is that this district judge was dealing with a singularly dangerous individual and with a long history of multiple violent acts involving drugs and firearms. And what he sought to do is to further the Sentencing Commission's goal of, and Congress's goal of deterrence, and write something that was broader in order to give some flexibility to the probation officer to protect members of the public and the probation officer himself or herself. And much of what we're talking about is down the road in terms of, there's been no search of a computer at this point. There would have to be reasonable suspicion to search the computer. But that's down the road. And what you have here is a district judge trying to craft a position of a special condition of supervised release that will allow this individual to be out on supervised release, and that will fulfill the district judge's obligation to make sure that yet another violent act doesn't claim the life or injure some member of the public. And so he errs on the side of deterrence. He's got some flexibility in that. We've said time and time again that district judges have broad discretion in crafting supervised release. And if this record of this violence doesn't justify some broad prohibitory deterrent, then it's hard to see what would.
Yes, Your Honor. I see my time is up. If I may have just a moment to conclude. This is the second time the district court has sentenced the defendant. And I think that when you look at the sentencing hearing, this was an example of an individualized sentencing. There was significant discussion of his history, the nature of the offense, his history of violence, and the drug history. And the court cited those in support of the warrantless search condition. We believe that the condition is procedurally and substantively reasonable and should be affirmed.
One point that was raised, and I assume you agree with Judge Wilkinson's comment about in terms of this was particularized to him, correct?
Yes.
Well, do you know in the Fourth Circuit, we have said as a matter of law in the Fourth Circuit, without any evidence of it, that guns automatically go with drugs. Did you know that that's the law in this circuit? That drugs and guns are just presumed to be coming together. We said that in several cases. You know that?
Yes.
Therefore, so the part about a gun here is nothing particularized at all. Once you're a drug dealer, the gun's presumed involved, right?
Your Honor, I would disagree with that generalization as to this record. This defendant.
No, I'm not talking about this record. We just don't adjudicate cases just for this. We have to look at it in the broad scheme of things. That justification exists with everybody who's involved in drug transaction because it's a likelihood that you'll have guns. Whether it's right, because when you have drugs, guns are presumed, right? Is that right? You know that.
There is language to that effect, but again, I think we're focusing on the individualized context of this case. And we have a defendant who has 2 offenses for carrying a concealed weapon. Okay. He's also discharged a rifle into an occupied vehicle. He's assaulted somebody previously with a firearm, and he went to a drug transaction that ended in a shootout. So in this particular case, the court's concerns about drugs and guns were well-founded in the record.
What about computers?
Again, the court crafted a broad,
Very broad.
a broad condition of supervised release that was focused at both promoting the rehabilitation of the defendant and accounting for the fact that he has a horrible history of drug and gun offenses. This defendant, I think, has 9 possession of marijuana offenses, 3 state felonies related to possession of Schedule II or possession of cocaine offenses, and he went to a drug deal with a gun, and it ended in a shootout. In the district court, after discussing these facts at length, talking about his failures on state supervised release, state probation, he had more drug convictions after he bonded out on state charges related to this crime. There was a legitimate concern about deterrence and protection of public safety, protection of the probation officer. And to that end, the court allowed warrantless searches. And I think that given that this is the second time the court has authorized warrantless searches, it believes that they're appropriate on the facts of this case. And this was an example of a thorough and individualized sentencing. And I acknowledge that there was no discussion of the computer. But again, by the terms of the condition itself, for a law enforcement officer to conduct the search, there must be reasonable suspicion. And I think that reasonable suspicion must be as to finding something on the computer.
And where did you get that from? What cases are you citing that a probation officer is required to that? Can you cite
I
the
said a
case?
law enforcement officer. It's required by the term of the condition.
No, the probation officer can do this, correct?
The probation officer can conduct a search in the
That's what I'm
lawful
talking about. Show me
discharge.
the case that he or she is required, what you just laid out as, in that. There is none. Are there?
The probation officer cannot act with purposes of harassment, cannot act arbitrarily and capriciously. And probation officers, again, Supreme Court case law recognized that probation officers are different in that they do have their client's welfare, which is, the defendant's welfare, and there is an ongoing probationary relationship and certain obligations that will inform whether conducting a search is the appropriate step.
You just argued full circle because it's almost like an in loco parentis type relationship. That's why it's very open. I can see your computer. I just want you to be on the straight and narrow. That's the relationship. That's why we have to be very careful what the conditions are. Right? That's what our boss said. But that's all right, never mind. You finished, Counsel?
Yes, thank you, Your Honor.
Thank you very much. Ms. Niston?
Thank you. Just briefly, Your Honor, Chief Judge Gregory, I believe you're exactly right to focus in on Arbaugh. And Judge Wilkinson, the condition in Arbaugh was warrantless searches of the computer. The defendant there was not restricted from using a computer. He was just open to warrantless searches. And again, Chief Judge Gregory, I think that you identify the danger here that if we're going to allow warrantless searches of computers and cell phones for just the fact that someone is either violent or, has a gun in the past and has done
a lot
violent
of
things.
this is unforeseeable in the sense that the nature of the violation that the probation officer comes upon, we can't tell right now what that future is going to bring. And given the fact that the nature of the supervised release violation is unforeseeable here and now, doesn't it make sense to give the probation officer some discretion, cabined as it is by reasonable suspicion? Because this is not an individual who is subject to the presumption of innocence. It is an individual who has been convicted multiple times. And so the Fourth Amendment of violent crimes and the kind of Fourth Amendment concerns that we would rightly apply to people who have not been convicted and who are searched ab initio are simply different on supervised release. They are not the same Fourth Amendment protections for someone on supervised release as they are for any American citizen who enjoys the presumption of innocence because they have not been convicted of anything, or at least not of a long string of violent crime.
Your Honor, to the extent that the future is unforeseeable, we can only base, I think that would allow a court to impose anything by saying, well, the future is unforeseeable, so we're going to impose every condition there is because we don't know what this guy might do. I think you have to base, as this court has said, you have to base the conditions on something in the record. And in this case, there's simply nothing in the record to support this, especially when this court has said the statute requires the condition must involve no greater deprivation of liberty than is reasonably necessary. And in this case, based on this record, the warrantless search of the computer and the cell phone is simply a greater deprivation of liberty than is reasonably necessary. And I would encourage this court to follow Arbaugh and find that the district court's explanation here and the record simply does not support imposition of these conditions. We ask for this court to either vacate the warrantless search condition or to send it back to the district court for a more fulsome explanation. However, I do feel that ultimately, at least as it concerns the computer and the cell phone, there is no support in the records. We would be satisfied if this court were to simply strike those parts of the condition. So for these reasons, Your Honor, we'd ask you to vacate the judgment and send this back. Finally, Your Honors, I would just like to take a moment to share with this court something I learned recently about my friend, Christine Fritz. This is her 51st oral argument before this court. I was unfortunately not here for her 50th, but I would just like to say that the Federal Defender's Office finds that Ms. Fritz is always a very fierce but very fair advocate, and I know that this court appreciates her advocacy, and we very much appreciate it as well. Thank you, Your Honor.
Thank you, counsel. That was a wonderful touch to do that. It's nice to have counsel across the aisle there to reach out and do that. And I add your congratulations there. And, maybe this was a memorable one. All right, counsel, thank you so much. We'd love to come down and shake your hand as we normally do in the Fourth Circuit, but we can't under the conditions. But no, nonetheless, we appreciate your arguments and wish you to be safe and stay well. Thank you so much. All right, we'll proceed to the next case. Thank you. Fredericks, when you're ready.
Thank you, Your Honor, and may it please the court. We're here on an appeal of a dismissal on a Rule 12b-6 motion. If you look at the record, you might have thought that perhaps we're at summary judgment, but this is a 12b-6 motion. I want to start by trying to make clear what this case is not about. Defendants have tried very hard to say that this is a case about a mere inactionable disagreement about the interpretation of data relating to overall survival, which clearly was highly material in this case because the defendant's product was undergoing testing to try to show that it was superior to an existing drug, trastuzumab, which has been around for 20 years. It has a well-established record as a successful and an effective treatment against breast cancer. given that there was an existing effective treatment against breast cancer, investors were obviously highly interested in knowing not merely whether the drug was also effective, but whether it was, to coin a phrase, a better mousetrap. Because if you have a choice between buying a mousetrap that's worked for 20 years and has a long record, no safety problems, all the bugs have been worked out.
What misleading statements do you say were made?
Well, the primary case in point on statements, Your Honor, is they said that the interim overall survival data was trending positively as of February, just before they went to market and raised $126 million in a secondary offering. They said it again in May before the actual trend data was presented at ASCO.
Well, when did they have the information about the Kaplan-Meier curves? That's really the essence of the case, isn't it?
Your Honor, that's certainly one of the key issues, particularly as to Cyander.
Did they need that when they went? Did they need that for their submission of this thing to ASCO to determine whether it could be presented at the meeting?
Your Honor, I think that drug companies have discretion in what they choose to present to ASCO or not. ASCO is not a government regulatory body.
I understand, but you got to meet ASCO's standards, and the question is whether they knew about the bad Kaplan-Meier curves back in February.
Your Honor, let me give you a couple of reasons as to why, certainly on this record, there's a strong and compelling inference that they did. First of all the data that was disclosed at ASCO was from a data set that was locked in October of 2018. We're talking about them discussing the data for both PFS, progression-free survival, and overall survival in February of 2019, 4 months later. Their own statement said that they were tracking the OS data. They went and told the market, we have positive trending data. The trend is positive versus trastuzumab.
You're being selective there because both in the press releases and the call and the filings that were made, the discussion of the OS is just replete with cautionary statements. It seems to me they go out of their way to say this data is preliminary, it's subject to change, it can go, the tests are ongoing, and that, it seems to me, is the prudent thing. I mean, this is typical. It says, for example, the achievement by margetuximab or whatever it is, to the primary endpoint of progression-free survival does not indicate whether the co-primary endpoint of overall survival will be achieved. And it seems to me that that's about all you can say about OS survival as opposed to progression-free survival, because you don't know the endpoint of OS survival until you track patients for a long period of time. And that hadn't happened here, and so the company says, look, we need to alert people that this is simply, with respect to OS survival, this is simply preliminary, and it's subject to change, and it's fluctuating. And given the fact that OS survival rates are not going to be known for a long, long time, it seems to me only prudent for the company to separate progression-free survival and OS survival and make particularized comments with respect to each.
Your Honor, let me try to address your comments head-on, because I think that the district court had similar concerns, but I don't think appreciated the underlying facts. Let me just briefly finish in 15 seconds answering Judge Gibney's question. How did they know of the data? The only trend data that's in the record is the Kaplan-Meier curve data. There's no other trend data that they cite to. They have the best lawyers in America on the defense side. They can't cite a single other trend data. And they said the trend is positive. If they didn't have any trend data at all, then they shouldn't have been opening their mouths. And if they did have trend data, the only trend data was bad.
So your point is that,
and I do want to get back to Judge Wilkins.
but your point is that while they may have put all these caveats in there, if they say, well, it looks really good, but don't say the damning evidence about the Kaplan-Meier curves, that it's an omission that is fatal to their defense.
I think I could try to address both of your comments in the same blow. Your Honor, Judge Wilkinson, they were not silent on the OS data. They put that subject squarely in play. They say, we have OS data, we're watching it, and the trend is positive versus the established trastuzumab. That was music to any investor's ear. And of course, you always have risk that, when you complete the analysis, the data will change. But when you tell people things are looking great,
That is
that's
what they
material.
said. They didn't say that.
No, Your Honor, and thank you for correcting me. They said that the data...
That's your gloss on it.
No, Your Honor, let me be very precise, and I appreciate your correction. And I want to focus exactly on the words they used, because the words they used are important. They said that the trend in the OS data is positive for margetuximab, and that effectively meant positive for margetuximab versus trastuzumab. What that means is, okay, they're saying if you look at where the data is going, the best data we have, where is it going? It's going favorably to margetuximab. Now, what we've alleged in the complaint, and this is the only evidence on trend that there is in the complaint, is that Kaplan-Meier analysis is the gold standard, is the method for looking at preliminary OS data to see where it's going. There is a recognized scientific method for taking preliminary data and making an assessment as to where the trend is. It doesn't mean that the trend is set in stone and nothing can happen, but it's the way you do it. It's Kaplan-Meier data. So if you look at the Kaplan-Meier curve data, it's in our brief, it's in the record. You see the separation in the curves. That separation, the trend is margetuximab or trastuzumab separating favorably from its competitor. You could be a fourth grade science student and read the Kaplan-Meier curve to say that
A reasonable investor would know the difference between progression-free survival and overall survival. And they would know that you can come forward with evidence on progression-free survival because that has a 5-year or whatever endpoint. But overall survival is by its very nature tentative until it's over a longer period of time, and an investor would know that. The one thing I want to point out here is that, with breast cancer, it's caused so much anxiety, and it's caused so much suffering. And there's a real need for treatments and improved treatments. And there's a danger here that the treatments that are really needed to reduce this anxiety and suffering that goes along with this terrible illness, are going to be kept off the market because those who are doing the treatments are likely to know that almost anything is going to be met with a securities fraud lawsuit. And the question that I have is, this is the very danger that the Supreme Court in the Tellabs decision was concerned with, and it's the very danger that Congress was concerned with when it passed the PSLRA. This court has been concerned with that danger. Just 2 weeks ago or whatever, Judge Motz and Judge Heitens and myself dealt with some of these same concerns, and it seems to me we are in danger of really going against the grain of what Congress wanted to achieve with the PSLRA and what the Supreme Court wanted to achieve with Tellabs, and what our precedent over a long period of time has tried to achieve. And that is, you don't want to discourage innovation in an area which is in need of good treatments because of the suffering it causes in particular. And these suits can keep innovation off the market. And that seems to me a danger here.
Your Honor, if you read every Supreme Court opinion on securities fraud cases, they will echo to some extent the concerns Your Honor has raised. But they have also emphatically, repeatedly, I would dare say over a dozen times, said that private enforcement of the federal securities regulations is a vital supplement to SEC and regulatory action. There is a heightened standard with respect to one element, scienter. And I might ask the Court's indulgence for a little extra time just to address the scienter element, as to which there is a heightened standard. But here, with respect to innovation, and I lost my mother-in-law to breast cancer. I'm not insensitive to the importance of having new treatments. But drug companies do not have carte blanche to say whatever they want about drugs that are in development. There is no exception for
whatever they wanted. If they were going to say whatever they wanted, there are almost a dozen cautionary statements here that indicate that the top line could change, that it's all in fluctuation, that it's all open. That's not saying whatever they want to say.
Your Honor, let me address the legal standard which is applicable. The legal standard is whether the statement that the data is at this moment in time, the data we have, the data from the October 2018 data set, is it fair to say that that data was trending positively? Is that a material misstatement? The standard that this Court and the Supreme Court have articulated is it, would a reasonable investor...
But you have to consider you have to consider that in the context of the cautionary statements and the entirety of the information they put out.
I agree, Your Honor, but the standard is, as a matter of law, could the district judge below say that the statement which falsely characterized the trend data was immaterial as a matter of law? When the ASCO data and the Kaplan-Meier curves came out, they were certainly material enough for Macrogenics to put them into a 15-minute slide presentation at the world's premier cancer conference. When those Kaplan-Meiers hit the wire, within hours, the stock of Macrogenics, they lost hundreds of millions of dollars of market cap. And Your Honor, you are correct. We don't want to stifle innovation, but the law is very clear. Congress says you can say nothing about your efficacy data. They didn't have to say anything about this data. They could have just waited and presented everything. But if you're going to open your mouth, you cannot cherry pick. And all the cautionary language in the world oh, the data may get better, will not cure a false statement as to the data now.
May I ask you a question about scienter?
Yes, sir.
Do they have to prove scienter for the individual defendants as well as the corporation?
The scienter of the individuals will be imputed to the corporation. There's quite an academic debate as to whether you can have scienter imputed to the corporation and not to any named individual. In the case, I would say yes, but I think in this case, scienter is clearly pled as to both.
Well, okay, what facts are there that show that these, I understand that as for the corporation, they had all kinds of people involved in the SOFIA study, including some sort of vice president for clinical development. So the corporation may have had scienter. But what about these two guys who made the statements?
Well, if the guys who made the statements, the defendants, Dr. Koenig and the other gentleman, if they open their mouths to say the data is trending positively, and they hadn't looked at any data, that would be a grossly reckless statement to just tell investors, oh, we think it's good because I think it's good. You have to have evidence when you're telling people serious, concrete data about clinical evidence. Certainly, the presumption, the reasonable assumption here, the compelling assumption, is that they did have
Well, this is sort of like the core operations theory, isn't it?
It's partly core operations, but it's partly the defendant's own statements. It's in the records in our briefs,
Well,
where they say, we are tracking the data. How can you say, we take them at their word.
Well, but doesn't the Fourth Circuit say you can't use the core operations theory to create scienter?
Your Honor, our first argument is that the defendants themselves say that we were tracking the data. I don't think there's any serious argument that the Kaplan-Meier data would have been performed. And in fact, if they said they were tracking the OS trend data, again, on this record, the only OS trend data that exists is the Kaplan-Meier data. They haven't offered any other alternative analysis. As far as we know, there still is no alternative. There's no Wilson-Son CD analysis that competes with the Kaplan-Meier analysis. So if they had any data on trends, it would have been the Kaplan-Meier data. They said they were tracking it. They characterized it as positive. They put it in play. And just again, in answer to Judge Wilkins' question, they could have said nothing. They should have said nothing. But the law of the land and of Congress, which we all live under, is that you cannot cherry pick data.
What they might have said, they didn't need to say time and time and time again that these OS figures are purely preliminary, that they could change. They go out of their way. They didn't need to say any of that too, either. You say, well, they didn't need to say that it was trending positive, but they didn't need to put in cautionary statement after cautionary statement after cautionary statement, none of which adhered to their advantage. In fact, it was to their disadvantage. And the question we are required to ask under TELADS is the culpable explanation more likely than the innocent explanation? And why in the world would a company that is bent upon deception go out of its way to say we're not overselling the OS results? Because time and time again, both in the press release, in the call, in the filing documents, they're all replete with cautionary statements. And I say what I'm concerned about ultimately is that with securities fraud cases like this, which are open to very large judgments, I worry that treatments that could be of enormous benefit to people who are, to women who are suffering from a devastating condition, that people aren't going to go on the market. Now, your response is, well, they can go on the market as long as they do it honestly. But again, this isn't just one cautionary statement, it's not two, it's not 3, it's not just one forum, it's not just in a call, it's not just in a press release, it's in all of them, every single one of them.
Your Honor, let me briefly address your question and then give opposing counsel an opportunity to respond. Let me try to give a very common sense, or let me give an analogy, which I hope is persuasive. You get a call from your child's teacher. He says, it's only halfway through the semester, but your kid's doing well. You know, I like where it's going. I mean, we'll see where the final exam is, but I like where it's going. Is there a material difference between a teacher saying that and saying, you know, Judge Gregory, the interim data is in, and I'm afraid it's not looking good. The data may change, you know, it can always correct, things may come up, but things aren't on a good track. If you think that there's no material difference between saying those two things, then I think you'll decide the case a particular way. If you think there is a difference between saying those two things, I think you'll decide it another way. And my client, a pension fund, City of Baton Rouge, invested a large amount of money in this stock. They bought in an offering where the stock price went up by basically 2.5 times when they came out and misrepresented the data. You know, they took a $10 stock, popped it up to over $20. They did it based on false and misleading statements. It wasn't an accident. They weren't required to open their mouths. They did open their mouths. They did so in a false way. And on this record, pre-discovery, we respectfully submit that the evidence is clear that they had actual knowledge of the real data, that was the only data that there was. It was adverse. They made a false statement. They can come back at summary judgment and say they're innocent, but at the pleadings, we respectfully submit that this meets the higher test that Congress has set. I'll yield, and I appreciate the court's indulgence for extra time. Thank you, Your Honor.
Thank you, Mr. Frederick. Ms. Locker?
Thank you, Your Honors, and may it please the court. There are 3 independent grounds on which you can easily affirm. First, under Omnicare, because Dr. Koenig's statements interpreting the interim OS data were non-actionable opinions. Second, under this court's decision in Paradise, because, as Judge Wilkinson said it much more articulately than I could have, Dr. Koenig's statements were absolutely cautionary and filled with warnings of the very risks plaintiffs complain about. And third, under Scienter. I'd like to start by focusing on Dr. Koenig's cautiously optimistic statement interpreting the OS data, overall survival data, as trending positively.
Well, what if he knew about these curves?
I'm going to go
What
right
if he,
to that.
doesn't he have an obligation to tell him that if he knew about it?
No, Your Honor. Now, Mr. Frederick says, and he said it in his reply brief, he said it here this morning, that the KM curves were the only trend data, and that the curves were trending against margetuximab. But plaintiff did not allege this in its complaint. He didn't allege that the KM curves were the only trend data. I would refer the court to paragraphs 10 and 70 of the complaint at pages 19 and 39 for that, to see what they actually alleged about the KM curves, and they didn't argue that below. And there's a reason for this. Even setting aside those problems, a 4th grade science student can tell that that's demonstrably false. And the quickest way to see this is to turn to page 140 of the joint appendix. And if the court prefers, I actually have laminated copies, enough for the panel and enough for opposing counsel. It is the key piece of evidence in this case. It's incorporated by reference. Plaintiff even pasted a copy of this in their brief, although chopped off, a very significant part of this slide. And again, we have copies. We can hand them to the courtroom deputy, laminated, but if not, you can turn to page 140 of the joint appendix. Now, what does this slide show? This slide has all the interim OS data. slide that Dr. Rugo presented at ASCO in June of 2019. There are 3 key measures of the efficacy of margetuximab right on this slide, and I'm going to point them out for the court, if I may. I'm going to start, there's a box on the left, which is the full intent to treat population, box on the right, which is that pre-specified subpopulation with the gene mutation F allele. What are these 3 measures of efficacy? I'm going to start from the bottom of the box and go to the top. First, hazard ratio, labeled HR. Second, median overall survival, labeled as median OS. And third, aggregate survival data, denoted as number of events or deaths. All 3 were positive in favor of margetuximab. Let me repeat that. All 3 were positive in favor of margetuximab. So the KM curves were not the only data available at the interim OS review reflecting how the data was trending. The curves were one piece of information of a much larger picture that Dr. Koenig had to interpret to determine how the data was developing over the course of the trial. The KM curve is no more a trend data or information than looking at the hazard ratio, the median OS, and the aggregate survival data, again, all of which was trending positively on behalf of margetuximab.
Well, but isn't this level, obviously I dropped out of science before 4th grade, but isn't this more of a summary judgment issue?
No, Your Honor, this slide,
Well,
wait, no,
but to
actually-
understand the slide, you need to have some,
Oh,
I need to have a very bright attorney explain it to me.
but, okay, but then why do you take plaintiff's interpretation of the data over defendant's interpretation of
Well,
the data?
because we're at a motion to dismiss.
No, because thank you for that question, Your Honor. So plaintiff alleges that the KM curves were trending against margetuximab. I'm going to get to that in a moment. You might think it's a little summary judgment. But plaintiff has conceded in their opening brief at page 32 that that's just their interpretation. That's a concession, just their interpretation. And what the cases say, and I will refer the court to the Second Circuit decisions in Sanofi and Kleiman, the Third Circuit decisions in Amarin and Pfizer, and district court decisions from the First, the Second, and this circuit in Karyopharm, AstraZeneca, and Shah, that a difference of opinion, a difference in the interpretation of scientific data is insufficient to establish falsity. It's nothing more than a disagreement, a scientific disagreement.
Yeah, they make 2 points. I mean, all of those decisions that you point to and all of the Fourth Circuit decisions and the Telabs decisions, they were all pleadings decisions. And what, Judge, the idea of leaving it for summary judgment, but those decisions were pleadings decisions.
All of them, Your Honor, yes.
All of them, each and every one of them was a pleading case. And you have to establish in the pleadings that the culpable evil explanation is at least as compelling as the innocent explanation. And when you get to the point of interpreting very complex data about which I suppose reasonable minds could disagree, but it's certainly a reasonable interpretation that you've put forward. Whether it's ultimately correct, it is certainly reasonable. And the disputation of that is often a matter of opinion. But we essentially, given the number of cautionary statements, and I haven't seen many cases where a company was looking for capital or whatever, where they have gone out of their way and bent over backwards to say, this is nothing but preliminary data. And if we say this makes a culpable explanation more likely in light of this slew of cautionary statements, think of the number of securities fraud cases that are going to be going against the grain of our precedent, the Supreme Court precedent, and what Congress sought to establish. And in particular, in this particular area of public health, as I say, that is the last thing you want to do is to shut off innovative treatment that could bring some relief and alleviation of suffering, which is of society-wide concern.
Thank you, Your Honor. I want to, I'm going to actually skip over my argument regarding warnings because you have articulated it better than I can. I want to address one comment by Judge Gibney, and then I'm going to turn to Scienter, if I may. Judge Gibney, the most, and I have a lot of arguments as to why, although they're going to sound like summary judgment to you, but these are all pleading cases. And I just want to point one thing out. When you look at JA 24 and you look at month 24, which is the point at which plaintiffs say that the KM curves were trending against margetuximab, you have 14 patients, a total of 2.6 of the patient population at that point. You want to talk about interpretation. Some experts, including Dr. Rugo, who spoke to these slides at ASCO, would say 14 patients, 2.6 of the population, that's anecdotal. You can't discern a trend from 14 patients and whether one dies or one doesn't die. So what we have is, at most, even if you credit plaintiffs' interpretation of the data, even if it was supported by experts, and it's neither, not valid, not supported, but even if it were, the most you have is information that's mixed. This is a concession by plaintiffs, and I would refer the court to JA 385 and 86 of their opening brief. That concession that the data is mixed should end the case, because under Omnicare, as we know from the Supreme Court, an opinion is not false or misleading simply because you have a fact that, quote, cuts the other way. Why? Because as the Supreme Court explained in Omnicare, investors understand they don't expect that every fact is going to support an issuer's opinion. These are quotes. Investors are aware that some of the underlying facts may be in tension with the issuer's opinion. So at most, we have a fact that cuts the other way. It's mixed. That's plaintiff's concession right there. Again, plaintiff's concession that this is really their interpretation of the data. So with that, I'd like to turn to Scienter for a moment. The essence of plaintiff's theory of Scienter here is that from roughly February to June of 2019, defendants concealed the KM curves because they purportedly would have shown that the data was trending against margetuximab. This theory makes no sense, and it's not supported by particularized facts. And I would say, Your Honor, that no, the complaint does not adequately allege that defendants had access to the KM curves as of February of 2019. You can look at data you can look at the underlying data, the hazard ratio, the median OS, the aggregate survival data without having the KM curves. But even if you assumed they had access to KM curves, Scienter would be woefully insufficient. First, it's simply implausible that Macrogenics, a biopharmaceutical company of limited resources, would spend 2.5 years from February of 2019, 2.5 years. You can find that at plaintiff's opening brief, page 33, note 13, and millions of dollars to complete a trial they thought was unlikely to succeed because the data was trending negatively. It wasn't on track to meet its endpoint, so says the plaintiff. That's the lesson of Casarelli. Second, and this is even more implausible, according to plaintiff, Dr. Koenig provided his opinion of the data, that it was trending positively, knowing that opinion was false, or with total disregard of the truth, but knowing that Dr. Rugo, a preeminent expert from UCSF Medical School, and the independent, I'm going to repeat that, independent lead investigator in a couple of months at ASCO was going to give her own interpretation of the very same data in front of an audience of, and this is plaintiff's words, premier oncologists and oncology researchers in the United States. And that's at paragraph 65 of the complaint, J37, and plaintiff's allegations and an argument that this is what Dr. Koenig knew that Dr. Rugo was going to present in a couple of months is at plaintiff's opening brief at 42 and paragraphs 58 to 59 of JA35. So let's step back and think about what plaintiff just said. Dr. Koenig lied, knowing that his lie was going to be exposed in a couple of months in front of an audience of the top oncologists in the country who ultimately decide whether to prescribe a new treatment.
Well, I don't think you're saying that the doctor lied, he's saying the company lied.
Well, it was the doctor, Dr. Koenig, who said
Okay.
that the data was trending positively. In fact, he said it on the February 6th.
Was he part of the investigation team? Was Koenig was not, was he? The investigation team was, they had some special guy that
Well,
was.
he is a scientist, he's a doctor, he's the CEO of the company. So no, he was not part of the
Okay.
unblinding team, but yes, he's ultimately responsible. I may be misunderstanding your
No, go ahead.
comments, but it was his comment on February 6th. It was his quote in May 15 press release, and he owns it, right? And
Did he do the presentation at ASCO?
No, Dr. Rugo, the independent investigator, gave her own interpretation of the data, and that's why I'm saying he's sitting there saying it's trending positively based on the information I provided to you.
Well, you asked why he would do that. The answer is they were trying to raise hundreds of millions of dollars to issuing stock.
Right, but this court, in Yates, Casarelli, Janney's, and Ottman, says that a motivation shared by all companies, such as raising capital, those are 4 Fourth Circuit decisions, this court, that's not enough.
Were
It
those
adds little.
cases, was in temporal terms, was the misstatement made as close to the stock issuance as it is here?
The alleged misstatement was made on February 6th. The offering was on February 13th. But in
A week later.
Right, but in Yates, and forgive me, I'll get the name of the other case, the alleged misstatements were in the offering documents. I mean, you talk about temporal proximity. That's what happened in Yates and Casarelli. Sorry, the alleged misstatements were in the offering documents. So temporal proximity is not going to bring you over the line. It still adds little to inference, and that's all they have in this case. No allegations of insider trading. Let me just also say,
Ms. Locker, may
Yes.
I ask you a question?
yes, of course.
Is it your position that the sole justification that would justify the statement that it's trending positively for this experimental drug, these 3 boxes that you talked about, and the KM curve?
Yes, Your Honor,
That's the sole basis for your, at this point, for motion to dismiss, that's the sole basis of justifying, they were justified in saying it's trending positively for this drug. Is that right?
there's one other point.
Okay.
But yes, it's those 3
Okay.
and the KM curves, because the hazard ratio summarizes.
That's why I said, yeah, the
Right.
CAM and the 3
Yep.
boxes, right? Is
but-
that anything else?
Yes, one other thing.
Okay.
Dr. Koenig was not the only one who thought that the data was trending in the right direction. At ASCO, Dr. Rugo said that it was too early to, her comments reflect that it was too early to draw from the KM curves because because of the expected immune delay, I'll explain that in a moment, the expected delayed immune response from margetuximab, which is an immunological drug, meaning with these immune-compromised patients, these cancer patients for whom other treatments have failed, they're immunocompromised, we all know about that. So she said she believed that the OS data was going to exceed the PFS benefit. I'll give you a cite for that in a moment. The PFS benefit, as Judge Wilkinson mentioned earlier, the progression-free survival, met its endpoint. It was statistically significant positive in favor of margetuximab. This is at page, at Joint Appendix 299, which is referenced in paragraph 76 of the complaint, and therefore this court can incorporate it by reference. So Dr. Rugo herself said she believed the data was heading in the right direction. Of course, she's independent.
So this is one of the exhibits you attached to your motion to dismiss.
Yes, Your Honor.
So-
And it is incorporated by reference.
It's incorporated by reference into your motion to dismiss, but can the court consider that in the motion to dismiss?
Absolutely. It is no different, Your Honor. It is incorporated by reference, and it is no different than the analyst report that was incorporated by reference in Casarelli, in which this court held that it supported an inference. What was in the analyst report in Casarelli was repeated by an analyst, forgive me. In Casarelli, there was an analyst report that repeated the company's statement that it wasn't going to disclose the endpoint because of competitive reasons. And this court, by incorporation by reference, accepted that as a fact to support an inference of non-scienter, of non-culpable reasons for the company's decision not to disclose the endpoint. This is no different. This is an analyst report, plaintiff cited at paragraph 76 of its complaint. I think it's JA 42, paragraph 76. And this court, it's incorporated by reference, this court can accept the facts as true. Just very quickly, this is not a close case. The company issued warnings underneath Janney's and Triangle that cuts against an inference of scienter. There's no allegations of insider trading under PEC and K-12. That too is inconsistent with an inference of scienter. And when you take TELABS as a whole, and you view all of the allegations holistically, the inference of innocence is much more plausible than an inference of nefariousness.
Ms. Locker.
Yes.
Talking about scientific significance, because we're talking about this is science, and these biopharmaceutical experts know what they're doing, and this thing that, but in terms of scientific significance, if you, and I'm saying if because this is the record, you stated you needed 385 events to be significant in making any finding as to OS.
Mm-hmm.
But when you come out knowing you only have 158, which is 41% of that goal,
Mm-hmm.
but you said there's a trend that's positive, but isn't that against the science? The science says you need this mark to make anything significant. Is that problematic that you make a statement that's forward-looking at that point when you know, wouldn't that sort of make people think that, oh, it must be something about this study right now that would, notwithstanding they're not where they're supposed to be to make a scientific significant statement. Is that important in this case?
No.
Okay,
Let
tell
me
me why.
explain why.
Sure.
Each one of the decisions that we cited, Sanofi, Kleiman, Pfizer, Amarin, Karyopharm, it is typical for companies to disclose interim data in each one of them, promising, encouraging, spectacular, actually, robust study results, okay? But that's why Dr. Koenig said, and here, he said it not just in SEC filings, he said it, and I'm going to give you exact quotes and cites for it, among other things, because it's at pages 11 to 15 of our brief. We just don't have, this is when he said trending positively. Dr. Koenig said, quote, "We just don't have enough events yet to be able to have significance here. So we'll continue to follow that." Quote, "The number of events were small, and again, we'll just have to wait with time to see where that goes." Quote, "It's too early to evaluate the secondary primary endpoint to overall survival as OS continues to accrue." Could not have been clearer. And in fact, if you look at plaintiff's own complaint, they said, everyone understood, this is paragraphs 55 to 59 at pages 34 to 35, everyone understood there was no statistical significance. It was interim. And he actually said, there was, in one of his quotes, there's only X, I don't remember the exact number, Your Honor said it, there's only X number of events.
Right.
There's no statistical significance. So with that, I'd just like to leave you with two thoughts. Number one, there's three separate grounds on which this court can affirm, and with the following. In Casarelli, this court recognized the danger of inferring scienter every time a pharmaceutical company that was trying to raise funds issued a bullish statement. It would, in this court's words, choke off the lifeblood of innovation in medicine by fueling frivolous litigation. Dr. Koenig's statements were hardly bullish. They were cautious, they were accompanied by specific warnings, and they accurately described the state of the interim data. It was his best assessment and interpretation, and Omnicare says that a different interpretation is insufficient to establish that it was misleading or false. If you have no further questions, thank you, Your Honors.
Thank you, counsel. Mr. Fredericks, you have some time reserved.
Your Honor, Macrotax Counsel and I agree on one thing: this is not a close case. She says that if you look at that slide on the Kaplan-Meier curves, there are three data which show the trend. That is simply false. The hazard ratio and the median OS data are a snapshot of what all the data looks like over time. It's like saying the speed of the car as it approached the intersection in the preceding 500 feet was 30 miles per hour. But what does it say about the trend that the car was speeding at? It says nothing about the acceleration. Nothing in the median data will tell you whether the car, when hitting, to use my analogy, whether it was accelerating recklessly into the intersection and it hit the intersection.
I don't understand what recklessness has to do with this in light of the cautionary statements, but when we're talking about scienter, we're talking about civil mens rea, which is generally thought to be knowing or willful or something like that. But it's a civil mens rea situation. I just, looking at this record as a whole, these are not evil people. There's an accurate and legitimate basis for what they're saying. Even if you don't agree with it, there is some scientific validation for what they're saying.
Your Honor, with respect, can I address that?
Excuse me a minute, excuse me. But does it really rise to the level of scienter, which is a mens rea kind of standard? I would, think that we would be literally stopping medical science in its tracks in this vitally important area if we let this case go past the pleading stage. That's what's at stake. Stopping medical science in its tracks when a case this thin would go forward.
Your Honors, let me go back to the fundamental point, which I think Judge Wilkinson, with all due respect, is misconstruing and where I started my argument. The only trend data is looking at the Kaplan-Meier curve data. It's like if you're asking, is Aaron Judge, off to a hot start, or what's the current trend in July? if he started the
Counsel,
season
there's a
hitting...
lot of room for dispute about this.
Your Honor, but let me respectfully say that counsel has misrepresented our argument, and let me clear it up in one respect. There may be some other data that they haven't yet showed us or put in the record that says, oh, there's some other different analysis than Kaplan-Meier that's better trend data. I don't know. We haven't done discovery. We haven't seen their expert witnesses. What we have said in the complaint is the only trend data that's in the record, the only trend data that we are aware of, maybe it's out there somewhere, but the only that based on our due diligence, the only trend data is the Kaplan-Meier data. That trend was not positive. It was negative. You can't say that the trend is going up when it's going down.
Was there any insider trading here?
Yes, by the company. It sold $126 million worth of its own shares at more than 2.5 times the stock price 6 days earlier. And let me just also say, in terms of their alternative trend data, there is not a shred of evidence that Dr. Rugo, the independent analyst, ever said that the OS data trend was positive. If you read the record, and I beg the court to read the record carefully, what Dr. Rugo said, or was quoted as saying by analysts, was, well, the PFS data is good, and so based on the PFS data being good, I expect the OS data to be good. That's characterizing, that's saying I'm making an assumption about where I think the OS data is going because I'm assuming a correlation. But that is not saying that the OS data itself is positive. That's why you do the studies. That's why the FDA does the studies, because they need to see the data. They don't want to have some theory that, oh, because of X, we can assume Y. They say, let's test Y. Let's test the OS data. The FDA made them test the OS data. It was a co-equal primary endpoint. It was critically important. The only reason why they approved drugs on PFS data is because you can get the PFS data earlier. It's really, everyone really wants to know what's the overall survival rate. Is it going to be better? That's what investors were ecstatic about. And they pulled the rug out from under them. And this is not Casarelli, where the allegation was, well, you failed to tell people that your study design was ridiculous and would never work. You know, and then you have the argument, well, why would you spend millions of dollars on a study design that you knew was wrong? Here, you know, they had a study design. It was a good study design. You have to do the study to get the approval. Unfortunately, you know, the data didn't pan out. There's nothing irrational or implausible here. And with all due respect, inferences of scienter and recklessness have to be inferred from the record. We don't have the benefit of looking into the computer of the drug dealer pre-discovery. But the classic way of proving scienter is, did defendants have access to information, not that cut some other way? This isn't like your Matrix where, oh, there's some junior lawyer who says this may be illegal when I have 5 partners all saying it's fine. This is the only data in the evidence, the Kaplan-Meier data, directly undercutting the statement that the data was positive. That's the only data. We don't even have a junior associate saying, oh, I have a different method of doing it. It's the only data. The data was going down, not up. This is, again, we respectfully agree this is a clear case. We haven't won on summary judgment, but we should certainly be entitled on the pleadings to go forward. I'm happy to answer any other questions the court has.
Thank you, counsel.
Thank you, Your Honors.
All right. Thank you, all of you. And as I said before, we can't come down and greet you as we'd like to, but know that we appreciate your arguments and we wish you well. Be safe. Thank you.
Thank you, Your Honor.
What's next is the Charlotte case?
Yes. Mm-hmm. Franklin v. Charlotte. Vargas, when you're ready.
I am, Your Honor. Thank you. May it please the court. I'm Luke Largess. I'm here on behalf of the estate of Dan Queers Franklin, his mother, Deborah Franklin. The court below found that it was nearly beyond doubt that when defendant Curl shot Dan Queers Franklin, he was complying with her order that he put the gun down, that he was taking the gun out of his clothing and putting it down. But it found that that mistake was reasonable. We appeal from that finding. We think that a jury in this case, on this record, could find that there was no immediate threat, that the conduct of the officer was incompetent, if not unreasonable, and unreasonable, and that the shifting explanations for the shooting by Officer Curl and Officer Deal, a jury could find that they knew the shooting was not justified. Their response to this appeal shows the need for a jury trial. They say it defies logic to say that she was attempting to comply, that he was attempting to comply, that he ignored the officer's proper commands, that he deliberately hid his hands, that he acted in a menacing way by not responding to them, and therefore their actions were reasonable. And in particular, they say that the shooting was justified because Ms. Curl perceived that that Franklin took the gun and began to turn toward her with it, so she perceived the threat and killed him.
Well, we can look at the video and see what happened.
We can, and Judge Mullen did not address the difference between what happened and what she described, which is one of the issues in this case.
So how do you get to the city on this case? That's my
Oh, I think under the Starbuck decision this
Well,
year.
but Starbuck is different, because in Starbuck, that's the school board case. In Starbuck, the school board, under Virginia law, the school board makes the ultimate decision about whether to suspend a child. So yes, it gets recommended up through various levels and preliminary decisions are made, but the ultimate decision whether to suspend is made by the school board. They were, in essence, the acting entity. Here, in contrast, the city government simply reviewed the action and did not fire the lady, the officer.
No, it's different than that, Judge Gibney. In this case, you had an ordinance that established the city manager as the final policymaker for a use of force. We went through the citizen review process. They recommended unanimously that the shooting was not justified, and he refused that decision. That, under Propotnick, is ratification of the decision. And that Marion v. the Hall versus Marion School District was this case's decision, another school board matter. But it's the same. The issue is whether there's a final decision maker under state law. And the ordinance established the city manager as the final decision maker. So
Well, but he didn't make the decision to shoot the victim.
But Propotnick is about ratification. It's not about making the decision and the action. And I think what's clear in Starbuck, Your Honor, is that there is no causation requirement under Propotnick. It's not a moving force requirement, which has been kind of this confusion in the law.
In Starbuck, the school board did cause the harm.
They ratified the action of the board in discriminating against the student for the speech.
They were the board.
Well, I mean, of the superintendent, of the school administrators, of disciplining the student or limiting the student's participation. They were ratifying, that's what the decision is. They ratified that lower decision. And that's what Propotnick is about, ratification. But let me come back to these three things that they rely on here primarily.
Well, do you think the city had a policy of shooting people who were acting innocently? Of course not.
No, but under Pembauer, you can have, sort of the sequence of events here is Manel says there has to be a policy.
Yeah,
Pembauer says it can be a single decision, can establish policy.
Yeah, but Pembauer that's the case where they searched the doctor's office, right? Exactly. And in Pembauer, there was an assistant district attorney who made the decision and told the police officers to go search the place. She was the moving entity in that case.
And then there was language in the case about whether you can delegate final policymaking authority, which
Yeah, you
led to
can,
Propotnick.
absolutely.
Which that's what led to Propotnick, Your Honor. And Propotnick sort of goes beyond it's about when does ratification make a municipality liable? And here, the city manager said that this shooting complied with city policy. Not that city policy advocates what happened, but that this complied with it. And
Counsel, I have some of the same concerns that Judge Gibney has. To me, I don't understand the basis for the municipal liability, because the municipality in this case had actually set up 3 different levels to review these shootings. They weren't interested in just dismissing it. They weren't interested in leaving it all up to the police. So you have a police department reviewing, and then you have a shooting review board looking at that, and then you have a citizens review board looking at that, and then you have a city manager. And the municipality should be given some credit for considering these cases carefully through this series of staged review. I'm afraid that if we say all the city manager decided to do is not to prosecute for a completed act, that somehow makes the municipality the moving force. And in addition, Counsel, there's some other facts here that I'd like you to address. This individual was removed from patrol, and as I understand, he was given a desk job as a detective, and also that the individual police officer was ordered to go through retraining. So there wasn't a situation in which the municipality just looked the other way. They removed the officer from patrol, and they ordered retraining. And when you look at the Supreme Court decisions and the emphasis of the Brown decision, that there at least has to be some moving force on the part of the municipality.
Your Honor.
I don't understand it there, because it seems to me that to the degree that the officer actually, she violated the policy of the municipality, or good police work would have you raise your hands and not say drop the weapon, which requires the suspect to reach for a weapon. But I don't understand why or how this municipality could be called on the carpet, given the way their structure has been set up, and given the fact that they did take disciplinary action.
Let me try to address your concern, Your Honor. It is the very fact that the structure is there that creates the legal liability under Propotnick. You have to go back to that decision, where if a final policymaker looks at and approves of the decision of a subordinate and the reasons for it, then the municipality is liable. It's a very simple proposition. It's essentially just condonation or ratification liability, which is understood in the law in lots of places. The confusion, Brown has nothing to do with condonation or ratification. And that's the confusion here. You have to go back and read Propotnick. And the city, they reviewed all this, but Your Honor, at every stage, internal affairs, the shooting review board, the city manager, the chief of police, all said that she acted consistent with policy. All of them. And which is the absurdity of this case, because they clearly are finding that she was incompetent and that she mishandled the situation entirely and caused this death as a result of her unreasonable mistake. but they said it followed policy, and that makes the city
Well,
liable
if it
under
followed policy,
Propotnick.
then why was she removed from patrol? And why was she required to undergo retraining? If somebody's followed policy, you don't have them retrained and you don't have them removed from patrol. They already,
And I want to make that argument in a jury trial, Your Honor, because the board, if you look at the record, the city, the shooting review board calls her back in and says, we find no policy violations. We find no training violations, but you have to be retrained. It's an absurdity in this record. And to sort of say that somehow that's the city should get credit for the way it handled this situation, the Citizens Review Board, if it's a jury in this case, unanimously said what you just said a moment ago. She gave the wrong commands. She forced this, she shot the man for doing what she told him to do.
that's fine, but that was not good police work. And if they thought it was good police work, they wouldn't have removed her and had her retrained. In other words,
But understand, Judge Wilkinson, understand that the way that you get to the Citizen Review Board is by the chief sending a letter to Mrs. Franklin that they found no policy violations and that the shooting was justified. That was the official position of the police department that let her go under the ordinance to have it reviewed by a citizens panel, which then said it was unjustified, asked the chief to change his decision. He refused, and the city manager agreed in deposition with every finding of fact of the Citizen Review Board except declared the shooting was justified.
See, the absurdity that you point out is not limited to this case. This is what happens in police shootings all the time. One of the favorite tactics is to appoint a Commonwealth's attorney from a different jurisdiction to review it, and they come back and say, well, there's no violation of the law, or there's no violation. It's a municipal practice that needs to end.
In
But
one way,
but that sort of begs the question of whether
there,
burying it makes it their policy.
but the policy issue is under Propotnick. The city 25 years ago established the Citizen Review Board, and this was the first time the Citizen Review Board had found a shooting unjustified in that 25 years.
Didn't the district judge also say that there could be no municipal liability because the officer was not liable?
That's the underlying argument, but I think that's the question I was trying to get to at the beginning as to
Well,
why the officer was liable. And
That's
she
not-
tries to argue here that he made this move, but the video shows he didn't, the autopsy shows he didn't, and she said she didn't. At the shooting review board, 6 months after the shooting, she tells the police department that there was no movement. She shot him as soon as she saw the gun. Because this was an active shooter situation. This was Uvalde or Columbine. She had to take out the threat. And the board said, oh, that's ridiculous. And sent her for retraining on how to take cover and give commands. But then announced, Judge Wilkinson, that she violated no policy or training. And that's an internal discussion, not one for public, like the Commonwealth attorney. But under that structure, there is a final policymaker who affirmed the action of the employee, and that creates liability. I want to just address that. There are a couple other things about the way this record is treated by
I
the
think there's a
defendants.
difference between ratifying something and deciding not to prosecute something. You can decide not to prosecute something.
Well, the prosecutor's
That
decision is
doesn't
separate.
mean that you ratified what was done, or that you moved to do that the city was in some ways a motivating force.
No, Your Honor,
All they decided was not to prosecute. But what they did do, as I mentioned earlier, was they removed her from patrol, which they should have, and then they gave her a detective's job, which they should have, and they required that she go for retraining. And then the city manager says, well, I'm not going to prosecute. But that doesn't seem to me to make it doesn't seem to me to make the municipality culpable when one considers the totality of the situation here.
But that's not the legal standard, Your Honor. The legal
Yes,
standard.
well, the legal standard is in Brown, which you have.
No, it isn't.
I'm sorry, I was quoting from a Supreme Court opinion.
Prodnik is the Supreme Court opinion that establishes ratification liability. Brown has nothing to do with that.
Judge Gibney points out this is a little different from Prodnik.
But I think what he was pointing, if you look at Starbuck, it reviews your decision in Hall v. Marion, it reviews the logic of Propotnick, and it's not that the municipality is the moving force in the violation, but that it has condoned it. That's the basis for liability. And there's no qualified immunity to the municipal liability of the city. My time is up, so I'll yield to Ms. Keaton.
Okay, thank you, Mr. Longcast. Ms. Keaton?
Good morning, Your Honors. May it please the court. I'm Lori Keaton. I'm here on behalf of Officer Wendy Curl. Summary judgment was properly granted in this case by Judge Graham Mullen because Officer Curl reasonably believed that DeCurious Franklin posed an imminent threat of serious harm.
Did you look at the video?
I did, Your Honor, several times.
How can you make that conclusion?
Because, Your Honor, we have a gentleman, if I may, who is, we know, what we have to look at here, Your Honor, is what did Wendy Curl know when she approached this scene? What she knew is we had a gentleman at a crowded Burger King restaurant in the 9 o'clock hour. He had a gun. She knows all this through the CAD report, so these are things that she knew. I'm sticking to only things that Wendy Curl knew, Your Honor. She knew that not only he had a gun, because we all know that possessing a weapon in and of itself would not justify a use of deadly force. He didn't just have a gun, Your Honor. He was pointing that gun, and he was going in and out. We know
Well,
that.
not at the time of the shooting, he wasn't.
Well, no, Your Honor, but we're not limited. We have to consider.
Isn't what happened here is that the officer panicked and shot the guy after he had been calmed down?
No, Your Honor, I think that's incorrect. When she arrives on the scene, they know that he's had a gun, that he's been brandishing that gun. They then see him with his hands clasped between his legs as he is squatting within inches of a man who we later found out to be Mr. Greer. Of course, at that time, Officer Curl has no idea.
I understand the report to say that the individual was brandishing the gun.
Correct, Your Honor. That is what the 911 call said, that he had been pointing and brandishing the gun. And then we have two 911 calls here. We have two 911 calls describing his appearance, that he was brandishing a gun, that he had gone to the Burger King to fight. And then we have him traveling both in and out of the restaurant. And then when they arrive, they see him crouched down on the balls of his feet within inches of Mr. Greer. For all they know, Mr. Greer could have been the gentleman that he went to the Burger King to fight with.
Let me ask you this.
Yes, sir.
One of the things that concerned me about this case was that Officer Deal, who was with Officer Curl, testified in this case that he was surprised at the way that Officer Curl was operating, and that she was crossing in front of him, and that she was, the individual gave the wrong, that Officer Curl gave the wrong command and the wrong instructions. I mean, isn't it a very dangerous thing to say that you should drop your weapon, which forces the suspect to get the weapon?
Your Honor, I think the question here is, was the mistake she made in believing the gun was between his legs reasonable? Because everything stems from that. They know he's had a gun and that he's been threatening with the gun. They show up, his hands are between his legs. They believe there's a gun there. And as Judge Mullen found, it was reasonable to believe that is where the gun was. And I will remind everyone, they began with the command, as you also mentioned, of show us your hands. That was stated 4 times. They then did not
Well,
give
they
any...
also commanded him to drop his gun, right? So how's
Correct,
he
Your Honor.
supposed to drop his gun without putting it in his hand?
Well,
Just
Your Honor,
stand
I
up and
think
shake
that-
it out of his pants, or what?
And again, Your Honor, I think the question here is this: was it reasonable of her to assume that the gun was between his hands, as both she
And
and
which way was the
Officer
gun
Deal?
pointing?
I'm sorry?
Which way was the gun pointing?
Well, I don't think at that point the gun was pointed anywhere. It
Well,
was between his
when she finally
legs.
saw the gun, which was the motivating factor for her shot, which way was the gun pointing?
I don't think the motivating factor for her
Well,
shot
which way was the gun pointing
the
when
gun
she
was
saw it?
pointing towards him. So
So-
it was not pointing towards Mr. Greer. It was not pointing
So
towards
in
the
order to
officers,
shoot her, he would have had to turn his wrist around and
which can be done in a matter of seconds, as any police officer would tell you, Your Honor. And as far as the crossing and the commands and the cover go, this type of, well, she could have done better, she could have responded differently, is exactly the type of judicial hindsight that's prohibited by this court. I would point the court to Anderson v. Russell, Elliott v. Levitt, Greenidge v. Ruffin. In all of those cases, we have exactly...
When they arrived at the scene, there was no resistance on the part of this suspect. There was no attempt to flee, at least as far as I could read the record. And wouldn't you have expected a more active sort of resistance? But am I wrong to read the record in saying that the suspect here was passive?
I think that things had de-escalated some from where they were before they arrived. However, they still had an armed man within inches of a patron, had no idea, as Mr. Greer said, of what he was going to do with the gun. And so the threat was still there. And so she couldn't just say, oh, he's fine, he has a gun, no worries. It wasn't just possession of a gun like the cases that plaintiff cites, the Cooper case and all of those, where someone's in their home with a weapon and they walk out thinking there's a disturbance. This is a very different situation. We're in a crowded restaurant and a man has a gun and he's already shown that he's willing to use that gun. So it was reasonable to believe his response made her believe he wasn't complying with their commands. He did not give any indication. He didn't make eye contact. He would occasionally gaze around. He was non-responsive. So it gave the reasonable impression that Mr. Franklin was not complying with the officer's commands. And so given the fact that we've got...
Which specific commands?
Well, there were 4 commands to show your hands, which he ignored. There were then 22 commands, I believe, variations of drop the gun. And so because they assumed the gun was in his hands, which was reasonable as they were clasped, and I'm not suggesting that he intentionally in some nefarious manner was hiding his hands on purpose, but you have to look at this from the viewpoint of Officer Curl at the moment it occurred. From her standpoint, they believe reasonably that that gun is right between his legs. He could easily pick that gun up in a moment. And we have cases in this jurisdiction, many that say you don't even have to have a gun for the force to have been appropriate. The gun doesn't have to be pointed at you for the force to be appropriate. So this case is no different than those cases. I understand that we look back now and it's the temptation is so great to say, golly, if you had just stuck to drop your hands, this might have turned out differently. But that is exactly what this circuit has repeatedly told us not to do in these situations. That's what qualified immunity is all about.
Again, what about Officer Deal, who was on the scene and he said he was shocked by the decision to shoot?
Well, I think what Deal said, and I think we have to remember, as many of the cases such as Sigmund v. Chapel Hill and other cases tell us, his vantage point was different than Officer Curl's. The whole reason Officer Curl ends up crossing and not having the cover that you would like her to have is because she needed to be able to be a good officer and see Mr. Franklin, see his hands, and see Mr. Greer. So that's why she moves. Deal was at a vantage point behind where he could not, and he admitted this, from where he was standing, he could not see what Franklin's hands. He could only see a part of him. And so I think to take what Deal said is I don't think Deal stands for the, quote, reasonable officer here. He wasn't experiencing the same thing that Officer Curl was because he was in a different spot. It's also important to note that Officer Deal ultimately said that he believed that Decurious Franklin represented an imminent threat and that he had regrets that he had not acted sooner and that he felt guilty about that. And so I think it's important to note that. And so what happens here is that she has the reasonable belief the gun is between his legs, They keep giving these commands. They're in their uniforms, they're in their police cars, the commands are loud and clear, so this isn't a situation like some of the other cases where there's a doubt if he knew they were the police. We then have bystanders come out, which only heightens the risk here because now we've got more people in the mix. And so all of this is happening, and so Officer Curl is having to make these split-second judgments about what to do. And I want to talk just briefly about what happened after, because you guys spent, I'm sorry, Your Honor spent a good bit of time on what happened after the shooting. And we talked about, oh, well, she was removed from patrol, and that she got more training, and that these sorts of things. And plaintiff makes a lot of discussion about the fact that the Shooting Review Board asked her hard questions. But I think it's important to note that there's nothing before you all in the record to suggest that she was removed from patrol as some sort of punishment. She was never asked in this record anywhere why she was removed from patrol. She went back to a prior job as a detective that she had held for 9 years. As far as the training goes, the appendix before you all makes it clear. The training was ordered by by Chief Jennings, who's now chief. Then he was deputy chief. Jennings made it clear that the training was ordered not because he felt that Wendy Curl had done something wrong, but because he felt that it was a traumatic situation and that you needed to be sure you were comfortable going back into the field if that's what she decided to do. And the fact that the shooting...
So there was no ratification. Is that your point?
So
Is that
I'm going to let...
They thought she was doing just everything fine.
So I'm going to let Mr. McCallum answer more on the ratification since he represents the city, but I would say, Your Honor, that I believe the city properly and appropriately found that Officer Curl's actions were appropriate given the scenario that she faced, given the fact that we're dealing with someone with a weapon that appears to have the hands hidden, the guns there. It appears to be a furtive movement, and it was reasonable of her to assume
Is there a training claim against the city in this case?
There's a negligent hiring, supervision, and retention, I believe, Your Honor.
That's a state law claim?
Yes, Your Honor.
Okay.
So, Your Honor, and I would just briefly I know that my time is running out, but to address some of plaintiff's cases. Plaintiff points the court to Cooper v. Sheehan, Hensley v. Price, Nibbs v. Montford, Stanton v. Elliott, and it's important to look at these cases because I think they illustrate why summary judgment was proper in this case, because you have to look at the difference between the cases. In Cooper v. Sheehan, we're dealing with a residence, there's a domestic disturbance, it's at someone's house, they fire without warning, he even calls out to see who's in his yard, and they do not answer. So there was no announcement there, and it's in someone's home. Hensley v. Price, it's in the daytime, and I made an error in our brief, and plaintiff pointed it out and said that the police, he didn't realize it was the police, he did. But in the Hensley case, there's no communication whatsoever. He comes with the gun in plain view by his side, so there's no question of it being hidden, and there's no presence, no commands given. So these cases the commonality in the cases that plaintiff puts before this court are that they involve situations of someone being in their home, and then they come out with a weapon because they believe there's a disturbance on their property. Or like in the case of Nibbs, the man is in his home when he is shot, and that is he's...
Prior to shooting, right?
I'm sorry, Your Honor?
Each of those cases involves the determination whether there was a threat that required a shooting, which is exactly what we have here.
That's right, but our cases, Your Honor, also other cases would fall under like Slattery v. Rizzo, Greenidge v. Ruffin, Gooden v. Howard, Milstead v. Keeler, and Elliott v. Levitt. Your Honor, those cases are more on point here because those are cases that occurred and there was a mistake made. Just like you all are saying that Wendy Curl made a mistake here, in every one of those cases, it is suggested that the officer at issue made a mistake, and sometimes they were pretty big mistakes. They go to pick someone up for the psych ward and they get the wrong person. They go to address the bad guy and they shoot the good guy thinking he's the bad guy.
Let me ask you this. Obviously, this is an issue which is, these shootings are an issue that has drawn a great deal of community and national attention, and for good reason. But I'm wondering if there isn't some therapeutic value or some community value to having a case like this, which is a close case and there's some disputed facts, to having it go before a jury, and having a jury of one's peers look at this and render a judgment. Isn't there isn't there some value in a case like this where the issue is as volatile as it is, to make to send a signal that the judicial system takes these cases seriously, and a jury is the best way to send that signal? What do you think about that? That's something I've been reflecting on.
And I think we have competing policy concerns here, but I also think what's important here is I do think there are cases that need to go to a jury, and you send those. This circuit sends those cases to a jury. And so like in Nibs, which was recently before the Fourth Circuit, that was a case where the officer's mistakes were not reasonable necessarily, and so you all sent that back for a jury to decide. That happens frequently. But the other competing concern here, and the concern that's implicated by the Curl case, is the doctrine of qualified immunity. And the fact that, yes, we need to answer for when police officers make unreasonable mistakes. However, we also need to give latitude when police officers make reasonable mistakes, because if we don't, they're going to be unable to do their jobs. If we're going to sit here and second guess everything they do in the benefit of this, beautiful courtroom way after the fact, that's going to be a problem for our officers, because they're not going to feel like they can ever safely use force when presented with a situation that requires it. So long as the mistakes were reasonable, then this is a case where qualified immunity should apply, just as Judge Mullen found.
Well, we look at the facts through the eyes of the officer, but we still view the evidence in the light most favorable to the plaintiff. So there's a tension there.
Absolutely.
Between the two of them. And that's why I think your esteemed opponent here is saying this ought to be presented to a jury, because people can look at it differently.
They can, Your Honor, and I think fortunately we have case law in our jurisdiction that helps us and educates us on how this should come out. And what I mean by that is I agree that this case should be looked at through the body-worn camera and through the facts most favorable to the plaintiff. That is the appropriate standard, and we do not dispute that. However, I think when you look at the case through that lens and you apply the case law in this jurisdiction, what we find is an officer who made a tragic but reasonable mistake, and we have to look at it through...
And the mistake was a mistake of fact, is that right?
No, I think it's like many mistakes in these cases. It's like looking and thinking someone has a gun when in fact they have a beer bottle. It is looking and thinking that someone is reaching for a weapon and they're reaching for a Walkman. Those were determinations this court made were reasonable errors and determined the officer was entitled to qualified immunity. This is no different. I'm asking this court to realize that Wendy Curl's belief that Mr. Franklin had his gun between his legs, clasped in his hands, coupled with all the other things going on, what the 911 caller said, the fact that there were other people around, we're in a public place, that it was reasonable to assume he wasn't complying with commands given the fact that he was not interacting with them, that he was gazing around. All of those factors should be taken into account to say that she's entitled to qualified immunity in this case, Your Honor. And also, the reality is, given where she thought the gun was, when he went to get the gun out of his pocket, it appeared to be a furtive movement. So I do think this is a conclusion that this court can reach and has reached in numerous other cases before, Your Honors. And just, I know I only have 40 seconds, but I would also mention the state law claims were properly dismissed here.
No, those seconds are increasing.
Oh, I've got all kinds of time. No, I'm just kidding. So the state law claim was properly dismissed because they were objectively reasonable. So for the same reasons that the federal claims were proper, the state claims were properly dismissed. And so I think it's important to consider that as well. And I would also want to address the Citizens Review Board. I do not think that these issues...
Counsel, did you understand that your time is up?
Okay. Oh, it is up. I'm sorry. Thank you.
Thank you. Mr. McCallum?
Is this my 5 minutes rebuttal, or is
No.
it-
Mr. McCallum.
I apologize, Your Honor.
No, that's okay. I know sometimes, that's why I was telling you, the seconds are going up. That means that's how much time over you are. Yeah, that's right.
Good morning, Your Honors. May it please the Court. Roger McCalman on behalf of the City of Charlotte. As indicated by Ms. Keaton, I'm here to discuss the issues of ratification as raised by the plaintiff in this matter. And in this case, one underlying issue that has been overlooked is all of the underlying cases that plaintiff cites to, there's a common theme. That common theme is that the final policymaker invokes the harm. That common theme is that the final policymaker has the ability to stop and undo the harm, place the person or student back in the position they were before the harm occurred. When we look at Propotnick, that was an employment law case. Mr. Propotnick had previously filed a grievance with the commission, and the commission agreed, and they undid his 15-day suspension. They gave him back pay, and they just give him a written reprimand. So at that point, the commission was able to place him back as before the injury occurred. When they finally terminated Mr. Propotnick, and it was deemed to be in retaliation, it was not until he had no further appeal left that that termination was final. Therefore, the commission ratified the retaliatory purpose and used that purpose to terminate Mr. Propotnick.
Did the commission make the decision to terminate Propotnick?
At the end, yes, Your Honor.
Okay.
When we look at case heard by this court, Starbuck. In Starbuck, footnote number 5, this court tells us that the school board had the ability to undo the suspension from the student's permanent record. That case was a case about the First Amendment and a violation of his First Amendment rights. The student gave some speech in school that the school did not like. The student was suspended at the school level. He appealed to the board, the last final policymaker. The final policymaker knew of the First Amendment violation. They had the ability to undo it. They chose not to, and that is when liability occurred to the school board and to the municipality. In the matters before this court, no such power is granted to the city manager. For such a power to exist, it would need something of the city manager is able to place Mr. Franklin back in the position prior to the incident occurring on March 25th, 2019. When we look at the cases, the common theme is there. We do not have that here. We do not have the ability to place Mr. Franklin back where he was. There was no affirmative action prior to the discharge of the weapon by Officer Curl that led to the shooting. When we look at Pambar, that case, before the officers broke down the door with the axe, they stopped and they called. A final policymaker was the one who reviewed those actions. He said, yes, break down the door to serve those subpoenas. Therefore, he was directly liable. He was the moving force in this matter. Our city manager in this case is not the moving force. Liability should not attach to the city. And as to the negligent training claim, plaintiff, per her complaint, she based the negligent training claim on a theory of ratification, which we are arguing does not apply in this matter. That is my time, unless you have questions.
Thank you. Thank you, Mr. McConnell.
Let me make just 3 observations in response to the rebuttal, if I may. The
Counselor,
first
could I
is-
ask, because you did not have a chance, we didn't give you a chance to develop the case on the merits of the excessive force claim apart from municipal liability. And your opposing counsel has made some comments, and he said we shouldn't hindsight this situation, that this was a split-second kind of decision. What do you say about that?
That's actually what I was going to address, Your Honor. The first thing is that all of the mistake cases that she cited and that Judge Mullen cited below are the inverse of this case. All of them are where the officer gave a proper command, most of them to raise your hands, where the person, after the officer leaves cover to approach the person then stopped following the command or never followed it in the first place. In Slattery, they opened the door.
But
It says,
wasn't
"Put
that
your hands up," and he
command,
doesn't.
excuse me, counsel, wasn't that command given here?
The command
Show your hands?
show your hands was given before they could even see him. The only command, you look at the video, the only command given to him after she crossed and has contact, that's when the seizure begins. They have the guns drawn on him and they are in contact with him and they tell him, drop the gun. That's the only command they give. And the chief said the only way he can comply with that is to take it out of his clothes. The only way. So it's the opposite of these cases. It's a totally improper command that he's following, not a proper command that he's
I
disregarding.
thought a command was given to show us your hands.
When they first get at the scene and get out of the car, they yell that, but they're on the other side of the car. They can't even see him yet. And they're not coming in with sirens. He doesn't, there's no, because he's dead, there's no record as to whether he even understood who was yelling at him. The only command given for the 32 seconds that he's in the body camera video, with him leaning close to Mr. Greer, who says that he slowly took the gun out and immediately
All right,
was
so
shot.
what do you say the officer should have done?
Well, if their concern is that we can't see his hands, you say, show me your hands. Everyone in the police department, this isn't judicial hindsight, Your Honor. Everyone in the police department, Mr. Deal, the investigators, then 2 days later, the shooting review board, the chief, a week after this shooting, the chief in a community meeting about the shooting explained how this is supposed to be handled. It's like a felony stop. You get the person back away with their hands up, and you either get them on the ground or put their hands behind so you can take them into custody. This was a routine matter that was calm, that they mishandled. And that's the basis for the liability.
Counsel, are you saying that under these circumstances that they should have approached him?
No.
What are you saying?
No, the felony stop is you get the person to come to you with his hands up.
Felony stop.
And this is what the Chief Putney said.
What had they been told that he had done?
They've been told that he'd had a handgun at the
Doing what with it?
threatening and trying to fight with someone.
Threatening, trying to fight.
Right.
When they got there, what was he doing?
He was squatted down like a baseball catcher having a calm conversation with the gentleman in the car.
Okay.
And the gun's nowhere to be seen.
And they made commands, and you're saying they should have said, "Put your hands up."
And everyone in the police department says that, Your Honor.
Well,
Why didn't you give that command?
Why didn't you get a command?
Why not? That is the trained command. Show us your hands. We think you have a gun. Show us your hands and keep your hands out so we can take you into custody.
Which hand moved first, left or right?
Well, she thought it
No,
was.
I've seen the videos several times.
But it's his right hand.
No, I'm asking you. No, which one moved first, left or right?
I don't remember, Your Honor.
You should know, because you're saying the police officer did something wrong. We know it was his right hand that he came up, right?
Right.
But which hand moved first?
I don't know, but what if I can say this?
Didn't
Your
he
Honor?
move his left first, like this, and then he came up like that?
Came up a little bit.
His left hand moved first,
And
correct?
what
Well,
she's-
no, wait a minute. Did his left hand move first?
I don't know, Your Honor. I'd have to look at the video. I've never looked at
Wait
that.
a minute, counsel. You're telling me that you have to look at a video. I assume you've looked at a video 20 times.
At least. And I've never focused on that question.
Well, I looked at it, and you go back and look at it. The left hand moved first, didn't it? Well, go with this, so you don't know. So I guess I can't question you because you.
But what Ms. Deal said, Your Honor, was that as
I'm not going by what Ms. Deal said. I'm going by what I saw.
But
And he was crouched over here with his legs seemed to be apart and squatting. And they asked him several questions. Didn't he turn to them without turning his body? He said, "I heard you the first time."
Right.
Didn't he say that?
Yes.
So we know he heard them.
Yes.
And he know he understood them.
Yes.
And what he did was he moved and he lifted it up. He lifted his hand up like this.
Right.
And
They
you
could
said
see
that
it was
was, you
empty.
saying there was no danger to the police officer.
They could see it was empty. When he went to reach, she could see that he had not had the gun in his hands. I'm not saying that there's no danger, Your Honor. I'm saying that the danger here her perceived danger comes from her incompetent handling of the situation.
Well,
She's supposed to, everyone in the police department says she's supposed to get him to get his hands up and back him away from Mr. Greer.
but the point isn't really, the procedures of the Charlotte Police, or wherever this was, the procedures of the police department don't define what the Constitution requires. The Constitution, and it has to be a reasonable action by the officer. That's really the question. And that's the question you think ought to go to the jury, right?
Yes, but they interact here, and this is
Well-
because the reasonableness of the seizure is her conduct during the seizure.
Okay, but it's not judged by municipal policy except for municipal liability. But as to Officer Curl, you look at what she did what she do is reasonable, and you reach the conclusion that she didn't, because she did not reasonably perceive a threat. And that's what you think ought to go to the jury. And you think that a reasonable officer, it's really not what Curl thought, it's what a reasonable officer.
A reasonable officer, and the other officer at the scene did not shoot as he
Well,
was
but
moving.
the other officer is not the jury or the judge in this.
But it's a question of the reasonableness of the officer. You have to look at how they're trained. The reasonable officer is the trained officer handling that situation.
But if it's that close, doesn't qualified immunity kick in?
No, because in those cases, Judge, it's where a proper command was given and not followed and a threatening move was made. Here, an improper command is given and he slowly complies.
Okay, is it not close when you have a report at a fast food restaurant that somebody is brandishing a gun, and when someone doesn't display hands in response to a command, and when you surmise accurately that the individual is armed, and when the individual looks like they're making a motion to draw a weapon, that's a close case. And the question is, in a close case, does qualified immunity kick in? It is a close case, but the question is, does that go to a jury automatically, or does it go under the rubric of qualified immunity's reasonable mistake?
Well, there's two issues here, Judge. One is that everyone in the police department thought her conduct was unreasonable. It's not judicial hindsight, it's police department hindsight. And number two, under Propotnick, qualified immunity doesn't apply, and this is a case against the municipality because they ratified what happened.
Well, but
And I think if you're going to find otherwise, you're going to be at odds with Hall, Marion, and with Starbuck, and we're going to have an en banc.
well, there are two cases here, one against the city, one against the officer. And with respect to the officer, isn't the question that the individual was complying with her command to drop the gun, and she then shot him?
Exactly,
And
which is what the chief
But
said.
that doesn't deal with municipal liability.
It's the individual, the only way, the chief said the only way that he can comply with that order is to take the gun out. The only way. Because she did not handle the encounter
Not what the chief said, it's not what anybody else said. It's what we reasonably perceive. And fortunately for you, you've got a video that shows what happened.
And the jury would learn that in the face of that video, they claimed that he took the gun out and put it in a pistol grip and pointed it at.
Well, okay, she may have lied about it, or
Well, it's
whatever.
not just May. That's a critical issue about the reasonableness of her conduct.
I mean, that's.
If they're making up a tale that doesn't fit the video, the jury certainly needs to know, why are they doing that? Unless they know that the shooting was not reasonable. So they make up what it was. I'm sorry, we're way over. Thank you for your time.
All right, thank you, counsel. Thank you both. Appreciate your arguments. We can't come down and greet you as we normally would, but please know that we appreciate your argument. These are very difficult cases. Thank you so much, and be safe and stay well. Thank you. We'll proceed to our last case for the morning.
So, Wiener
Your Honors, may it please the court, Ross Fulton for the appellant Malcolm Weiner. A jury found that AXA Insurance negligently entered false information about Mr. Weiner's health into an insurance database and returned an $8 million verdict for Mr. Weiner. Having lost, AXA is trying to repackage merits defenses that AXA already waived into a jurisdictional box. The district court's order made at least 3 key errors in deciding it lacked subject matter jurisdiction, any one of which requires reversal of the decision below. First, that the choice of law issues weren't already waived after trial. Second, that the Supreme Court's Bell and Steele tests shouldn't be used if subject matter jurisdiction was affected. And third, that Connecticut law should apply to the case and that the Connecticut insurance statute was anything other than a potential defense that AXA had failed to timely raise. The district court ruling here would have terrible consequences for the finality of jury verdicts in diversity jurisdiction cases in this circuit and invite losing defendants to bring extraordinarily late choice of law arguments couched as jurisdictional motions after waiving these arguments through the trial that they lost. Virtually all diversity jurisdiction cases will have choice of law issues by their very nature. The district court's ruling would allow losing defendants to strategically lie in wait on choice of law issues until after they lose at trial. Post-verdict here, AXA moved to dismiss for lack of subject matter jurisdiction, claiming for the very first time that a North Carolina statute provided an exclusive remedy for Mr. Weiner's claims. But that statute explicitly does not apply because it only applies to insureds who are North Carolina residents, and Mr. Weiner is a resident of Connecticut. AXA's post-verdict arguments are waivable and were waived by this post-verdict time period. North Carolina law was used throughout the case by both parties and by the court. And as noted in our brief, every circuit says choice of law can be waived. And certainly by the time there's a jury verdict, it is waived. This case was originally filed in North Carolina State Court, where AXA's office that submitted the false information to the MIB database was located. AXA removed the case to federal court based on diversity of citizenship, and both parties litigated the case all the way through jury trial based upon
If
North
they
Carolina
hadn't
state
removed
law.
the case with the choice of, would the subject matter jurisdiction issue have arisen under North Carolina law?
No, Your Honor. Under North Carolina law, we don't contend that it would have.
Suppose North Carolina had decided it should apply Connecticut law. Would the subject matter jurisdiction bar North Carolina case, state court from hearing the case?
No, Your Honor. I think that goes to the third point, which is that the Connecticut statute in question does not actually provide an exclusive remedy in the same way that the workers' compensation statutes cited by AXA do. Number one, here, there's no exclusive administrative forum for this relief. In fact, the Connecticut insurance statute provides for a judicial forum for these very types of disputes, and it provides for monetary relief for private parties under multiple circumstances, including the circumstances specifically pled in the complaint filed in North Carolina State Court here. Connecticut statute section 38A-996, which was the immunity provision, says that even if AXA had otherwise complied with the Connecticut insurance statute, even assuming that it did apply to this case, if they turned over false information about Mr. Weiner with malice, that is totally accepted from the Connecticut statute. In this case, in the original complaint, Mr. Weiner pled that these statements were made with malice. This is in the joint appendix at page 38. And that allegation is incorporated by reference into the negligence claim that falls below it in the complaint. So under circumstances exactly as those pled here, this dispute would not fall within the Connecticut statute at all. And because the Connecticut statute allows for a judicial remedy and money damages for injured parties like Mr. Weiner, we do not believe that this affects subject matter jurisdiction, and that instead what AXA is trying to do is take what could have been a plausible affirmative defense to claim either immunity or statutory preemption.
You touch on something that troubles me, and that is that during the pretrial activity, the motions for summary judgment, and the trial briefs, and the jury instructions and post-trial motions, it seems to me that AXA was citing North Carolina law and it was all in on North Carolina law being the governing standard of law. And then once the jury turned in an adverse verdict, they dramatically switched and said, no, the North Carolina choice of law rule requires that Connecticut law be the governing law. But they litigated the whole case on North Carolina law. And wonder if the jury had returned a verdict in their favor, I'm willing to bet that they would be screaming up and down that North Carolina law was the governing law, that choice of law questions are waivable, that they don't oust jurisdiction, that they are affirmative defenses. And so I'm left with the conclusion that there may have been some really bad sandbagging going on, or that we would open the door for some really unfortunate sandbagging in which people just hold their choice of law questions in reserve, and if the verdict goes against them, then they resuscitate the choice of law in a completely different position than they took throughout trial. And I don't, that's a hard thing to ask the district judge, which had gone through a very fine trial. And all of a sudden they're saying, well, this all went for naught. There just can't be.
Your Honor, I couldn't agree more. And AXA, as you pointed out, tried this case under North Carolina law throughout. It wasn't just in the motions practice. It was also in their proposed jury instructions. They proposed that the court instruct the jury on North Carolina law, and the jury was in fact instructed on North Carolina law. It wasn't until they lost, post-verdict, that they first brought up the fact they believed maybe some other law ought to apply, and maybe that law ought to be found to be jurisdictional now that they knew that they had waived the possibility of raising it as an affirmative defense, which preemption and immunity.
But am I correct? I think I am, because I've read a number of these cases. But practically every time it comes up, every circuit in the country has said that the choice of law question is a waivable one.
You're correct, Your Honor. Every circuit has found that.
Yeah, and we've held that as well. And so I wonder if we'd be creating a circuit split with ourselves, not just on the short end, but on the solitary end. And as the Supreme Court has said, we'd be engrafting another condition on diversity jurisdiction. These parties are diverse.
That's correct.
One of them is a citizen of New York, I guess, and one of them is a citizen of Connecticut or what have you. All right, they're diverse. And that's the jurisdictional question.
Your Honor, we agree. The parties are diverse. There's more than $75,000 at issue, and no one has ever disputed that in this case. The first time that this comes up, and Your Honor, it's in the Fourth Circuit, it was the Balancia case versus General Motors that found that choice of law.
Now, did they raise at any point during trial, did AXA raise at any point during trial that Connecticut law is the one that controls, and that Connecticut law, the exclusive remedies were statutory?
No, Your Honor.
Did they make that argument that the exclusive remedies were statutory?
No, Your Honor, never. Not until post-verdict.
Well, in fact,
Not until post-verdict.
post-verdict, they argued that North Carolina law deprived the court of subject matter jurisdiction. And then all of a sudden, you apparently mentioned the Connecticut statute, and the judge latched on that, and so I guess did the other side.
Well, Your Honor, I would agree almost with what you said. I would disagree that we were the ones who raised choice of law as a
So
possibility.
you didn't raise that, you just said even if the Connecticut law applied.
Your Honor, it was even different than that. We were using it by analogy to try and explain the North Carolina statute because they came from the same model act. There's very little case law out there interpreting the North Carolina statute. And so this was just by analogy saying, here's how another state's similar law would operate and why we should still win, we think, is what we were telling the district court. I would point out the district judge didn't think that we raised choice of law either, despite what AXA says in its response brief in this case. In the order that's up on appeal here, the district court states that it is taking up this choice of law analysis because AXA raised it in its reply brief. That's the joint appendix at page 998, citing the judge says, I'm bringing this up due to the newly raised possibility that some other state law might apply, and he cites to docket number 140, which is AXA's reply brief in support of its motion to dismiss. So that's the first time that choice of law came up as even a possibility, not only post-verdict, but in a reply brief in support of a motion to dismiss for lack of subject matter.
Did the parties
jurisdiction.
stipulate that North Carolina law was the governing law?
Your Honor, there's no formal stipulation in the record. There's nothing filed on the docket. However, at some point, the parties have agreed that North Carolina law applies. And for example, Rule of Civil Procedure 51, which is what this court cited in Valencia, if you don't object to the submission to the jury within certain prescribed timelines, then you've waived it. And in this case, not only did AXA not object to the jury being instructed on North Carolina law, they proposed it.
At bottom, Mr. Fulton, you're saying that the district court mistakenly thought that because Connecticut law might apply, it mistakenly thought that was jurisdictional as opposed to just a choice of law question, correct?
Correct, Your Honor. I think first, they mistakenly undertook this choice of law matter. We would contend that even if they were proper in doing that, which they weren't, that the Connecticut statute itself is not jurisdictional because it doesn't provide the sort of exclusive remedy that is found in the other cases cited by AXA from this court where an exclusive remedy was found to affect subject matter jurisdiction because there is no...
We've got our own precedent. There are precedents from other circuits. And there are strong signals from the Supreme Court that say subject matter jurisdiction is not ousted by choice of law analysis. This is choice of law analysis is something we debate in our cases all the time. And it doesn't oust subject matter jurisdiction. Our own cases say that.
We agree, Your Honor. That's absolutely correct. And I think here, it's not just the danger in this case, but it's the danger in future cases that we would see in the Fourth Circuit if this order were to stand, because we're going to be facing any diversity jurisdiction case in the Fourth Circuit is going to have a choice of law issue. These tort cases with lex loci being applied under different states' choice of law provisions, they're complicated. And it would allow a losing defendant to lie in wait, to sit back and wait to see, let's see if we win on the merits of the forum state's law. And if we lose, we'll get a second bite at the apple anyway. We'll get to come in and say, well, that state's law shouldn't have applied, this other state's law should have applied. And we'll find some statute that says, that this shouldn't be a possible remedy for the plaintiff, therefore it's jurisdictional, therefore I can bring this defense up. But that's what these are. These are merits defenses that AXA is bringing up way, way too late. They had every opportunity over the years and years and years that this case was ongoing to raise the North Carolina statute or the Connecticut statute.
The appellant's position here has the potential of just setting at naught a great deal of good trial work.
That's right, Your Honor.
It all goes for nothing.
Yes, it's very unfortunate this case went to a jury. It was, I believe, the first jury trial in Charlotte in the federal court in the Western District of North Carolina post-pandemic. And that work was just simply thrown away. Your Honor, I see I'm out of time unless the panel has any further questions.
Thank you, Mr. Fulton. Pronounce that
Sawchak. Thank you, Your Honor.
Okay.
Good afternoon, and may it please the court, I'm Matt Sawchak. 2 points show that the district court was right to dismiss this lawsuit. First of all, choice of law is not a freestanding issue here, as the earlier discussion suggested. It's connected with subject matter jurisdiction. The district court explicitly said on page 1013 of the joint appendix, the court needed to choose which state statute to apply in order to engage in jurisdictional analysis. That was the same pattern this court followed in the Banks case and in the Demetris case, where the court needed to choose which state statute to apply in a 12B1.
But weren't you choosing, in a sense, by the fact that you were all in on North Carolina law? I mean, you read your summary judgment motions and your proposed jury instructions, and you were all in on North Carolina law.
Your Honor, you're certainly correct that the trial record up to the point of the post-trial motions is citing North Carolina law. There really was not any choice of law debate going on between the parties.
But you assumed that North Carolina law applied, did you not?
We certainly took that position in our earlier papers. The second point about choice of law I'd make, Your Honor, is...
Well, but how can you back off of it?
Because it's connected with subject matter jurisdiction, just as it was in the Banks.
But I mean, just to be perfectly blunt, counsel, aren't you trying to pull a fast one?
No, Your Honor.
And yes, and holding back the choice of law issue until you see which way the jury verdict goes.
Your Honor, that is not what happened here. The district court explicitly said at page 1005 of the joint appendix, everyone was inadvertent to these insurance privacy statutes. Secondly, I'd point out the first person to mention Connecticut law applying was not AXA. It was Mr. Weiner on pages 963 to 72 of his post-trial brief. He mentioned it 12 times. And contrary to what my friend suggested, several times cited it in support of affirmative.
Oh, but that doesn't get you anywhere, because if one party is mentioning North Carolina law and another party's, even if assuming that they're talking about Connecticut law, that's just something for debate in the case. The point is the jurisdiction is established. The plaintiff is a citizen of Connecticut, and the AXA is of New York. And so you have diversity here.
Your Honor, that is an analysis that overlooks external challenges to diversity jurisdiction, such as the probate exception, such as the domestic relations exception, such as, most importantly here, exclusive state remedies. If citizenship and amount of controversy were enough, this court's decisions in Evans, Banks, Scott, and Balfour Beatty would all be overruled. Those were all situations where the mechanical elements of 1332 were satisfied, but there was an external challenge to subject matter jurisdiction because of these exclusive state remedies. Another point on choice of law is very important. There is no actual conflict between Connecticut law and North Carolina law here. The choice of law issue here, it's a false conflict situation. Both state statutes have the same exclusive remedy provisions. Mr. Weiner does not deny that.
Well, you would agree that the parties can stipulate or can assume that the choice of law issue, and generally courts uphold that assumption, as the North Carolina in this case was the law of the forum state. That would seem to be perfectly reasonable. normally courts can uphold that kind of thing, where the parties want to litigate under a certain state law. If that choice is completely unreasonable, like the Code of Hammurabi, then there would be a question on the part of the court. But why would there be a question here when North Carolina is the law of the forum, is the place of the forum state? And that's a reasonable choice.
It is, but it's not a stipulation, Your Honor. A stipulation is an active.
Well, maybe so, but when your briefs are loaded with discussions of North Carolina law and you're not protesting that Connecticut law should apply, haven't you waived the issue, and don't our cases say that the choice of law question is waivable?
And this court's cases also draw a distinction between waiver and forfeiture. Here, there's no active waiver alleged, so at most, it would be a forgivable forfeiture under the Alano line of cases. But, Your Honor, 2 points about choice of law, I think.
Well, hold on a minute, how do you get around our Valencia precedent?
Again, that is not a situation where choice of law was hooked up to subject matter jurisdiction. The district court here explicitly stated on page 1013 that it chose the law of Connecticut only as a step along the way. That's the very same thing that happened in Banks. It's the very same thing that happened in Demetris. When we have one of these state external remedy schemes that needs to be considered, necessarily one statute, one state has to be chosen. And again, my friend, I think, has no answer to the false conflict issue. There is no difference between these exclusive remedy statutes in the two cases. Now, my friend and his client try to come up with one by arguing here that the scope provisions of the two statutes create a conflict. But that argument has been...
If it's waiver on one hand or if it's forfeiture on the other hand, what difference does it make?
Waiver is not as easily overlooked as forfeiture is. Here, this would be a forgivable forfeiture. But again, I want to emphasize the point. I think the discussion is treating choice of law as if it were a freestanding issue. It's not freestanding, and there's a false conflict. Now, to try to come up with a true conflict, Mr. Weiner is arguing for the first time at the reply stage that the scope statutes exempt him from the North Carolina.
One thing to try to raise a practical point. AXA dealt terribly with this plaintiff, and the jury understood that. But this life insurance company made a total negligent finding that this man suffered from 4 serious medical conditions. And they humiliated him and they embarrassed him by sending out a report that he suffered from a cognitive disorder when he suffered nothing of the kind. And on top of that, this was done without ever speaking to plaintiff's primary care physician or with follow-up tests. And this is treating another person shabbily. He not only had his name besmirched, but he was rendered uninsurable, or in the alternative, insurable at a prohibitive and exorbitant price. And the jury understood it. And it was a good trial, and it was well conducted by an able trial judge. And now, after all of that is done and justice was achieved, we are supposed to believe that a party who has litigated the case under North Carolina law can all of a sudden pull out of its back pocket a choice of law issue and saying that, whoops, after all, Connecticut law applies and everything you did over this trial, it just counts for nothing. And this individual has, who thought he had achieved justice, had achieved nothing of the sort. And that is just not the way that the judicial system should work. It's not only unfair to individuals, it puts us on the short end, the sole end of a circuit split with respect to choice of law rules, and it engrafts additional conditions on subject matter jurisdiction in contradiction to what the Supreme Court has indicated. And I don't get it. I think it's a prescription for sandbagging. And it doesn't sit well with me. And I don't like what happened to this person. I don't like what happened to him at all.
I understand your concerns, Your Honor, but the same district judge who oversaw the trial himself recognized the lack of subject matter jurisdiction here.
So you say that under North Carolina law, there was no subject matter jurisdiction because the North Carolina Insurance Commission or whatever was the exclusive remedy for this individual. Is that right?
Ultimately, the district judge decided...
Is that what you say?
It would be true under both states' law.
Okay. So let's just assume that North Carolina law applied here. Suppose there was a defense under North Carolina law that workers' compensation should provide a benefit in this case, a different kind of diversity case.
Sure.
Can you waive that?
No, under this court's teachings in Evans and other cases, the displacement of tort claims by the exclusive state remedies...
But can you waive it if you go to trial on it? Like, suppose we had what we had here, they went to trial and then they said, well, sorry we lost, but it really was covered by workers' comp.
No, Your Honor, it's a 12B1 problem. I mean, that's the consistent holding of a long... I'm sorry, Your Honor.
Oh, go ahead.
Consistent holding of a long line of cases extending up to 2 weeks ago in Ziegler. Just 2 weeks ago in Ziegler, ultimately there were state law issues that prevented the 12B1, but this court recognized that exclusive state remedies are a 12B1 issue even there. Long line of cases, Evans, Banks, Scott, Balfour Beatty, Ziegler, Demetris, all of these cases treat these exclusive state remedies as an issue. And Your Honor, to your question, again, no conflict here. The same exclusive remedies apply under North Carolina and Connecticut law. I want to not neglect the point that Mr. Weiner has this true conflict argument he's trying to come up with fails for a number of reasons. First, it is not treated in his opening brief. That puts us within the Alhamdi case where, by his own admission in the opening brief, this is a true conflict. Second, to decide which state's law to apply, of course, we're within Claxon. The North Carolina law system would follow the explicit text of the statutes. One of the two statutes, Connecticut, applies to Connecticut residents. The North Carolina Supreme Court has taken that approach in Braxton. North Carolina Court of Appeals has taken that approach in First Union versus Brown.
Well, do you agree with Judge Wilkinson that you can waive a choice of law question?
Not, Your Honor, when it's connected with a jurisdictional analysis.
But ordinarily you can.
Certainly, if it is freestanding, but this case is nothing of the kind.
But in your theory, it would almost always be connected with subject matter jurisdiction. That's the problem. You would never recognize a freestanding choice of law question if this isn't a free. I don't understand how we're going to litigate this elusive phrase, as to which choice of law questions are connected to subject matter jurisdiction and which choice of law questions are not. That just introduces another level of uncertainty and complexity in the whole thing. The point is, the choice of law question is just like anything else. It is not jurisdictional by its very nature because it does not speak to the diversity of citizenship between the parties. If you have a problem with the forum, you cannot stipulate to it. You can raise a question of personal jurisdiction. You can raise a question of forum nonconvenience. You can do all of those things. But what you can't do is sit on your hands and let the case go forward under North Carolina law and then say, whoops, after the verdict goes against you. Here we are. I don't see what the problem is with reinstating these jury verdicts. The jury, in my judgment, had ample reason to rule the way it did, and I just don't see any problem with validating what the jury did. There was jurisdiction, the choice of law issue was waived, and it's not connected with subject matter jurisdiction, and it just, you don't oust, choice of law rules don't oust subject matter jurisdiction. They simply don't.
Your Honor, I would ask the court to take another look at Banks and Demetrius as examples of the court in a 12b1 setting having to choose which state's law applies. That's exactly what the district court did here. To the court's question about the facts of the case, a thing that might be helpful to the court is the district judge's own summary judgment opinion, pages 226 to 229. Code by code, the court goes through the MIB codes in question and finds a basis for them because all of them were qualified or evidence of or the like. Ultimately, this case was tried on a much narrower theory of sort of a process problem with the way these records were reviewed. You know, further on the so far nothing in our exchange has really said anything to cast doubt on the false conflict issue. Again, these two statutes, Connecticut and North Carolina, they both emanate from the same model act. And you know, I'd say this is a case fundamentally where it calls on the court, you know, although these late 12b1 situations are difficult, this is a rare situation where you have exclusive state remedies applying. But the dictates of Rule 12...
But do you realize that what you just said essentially gives the states that have state laws that exclude common law remedies, you're giving those states the authority to divest federal courts of subject matter jurisdiction. And that's, you know, that's vesting in state courts a remarkable authority over federal court jurisdiction to say that whenever a state has excludes common law remedies and has exclusive statutory remedies, that you can therefore say to a federal court, well, you don't have jurisdiction. That, you know, that can't be. I mean, that puts state courts in the driver's seat in a way that the Supremacy Clause and the congressional grant of jurisdiction and diversity, it goes against what the Supreme Court has said and said, don't pile condition upon condition upon condition upon jurisdictional grants. If there's diversity of jurisdiction, if there's diversity of citizenship, there's jurisdiction. You learn that first, you know, in the first class of the first year in civil procedure.
Your Honor, those arguments would result in the overruling of a long line of cases, the Evans line of cases involving exclusive state remedies. In terms of vertical choice of law on jurisdictionality, the court might want to take a look at section 3602.1 of Wright and Miller and its own decision decision in Shantae, the 1965 case that Mr. Weiner cites. This is probably the fountainhead case where the court discusses why state statutes like the South Carolina door closing statute can oust federal subject matter jurisdiction. Lastly, Your Honors, this is a hard case jurisdictionally, a lot like the Capps case a few weeks ago, where there was a late discovery there by this court of a subject matter jurisdiction issue, but the dictates of Rule 12H3 are clear. The district court recognized that, and we'd ask that the district court's decision be affirmed.
I just ask one question real quick.
Yes, sir.
At the close of the case, were you entitled to have to the jury being told that there was a preclusive provision in the statute that wouldn't allow this this recovery as a matter of law?
Were we entitled to have the jury told that?
Yeah, told that because or argue to the court.
Your Honor, I think that everyone...
You were entitled to argue that, right?
It could have been argued at an earlier point, but the district judge correctly realized that everyone, the court included, overlooked this statute. But the district court also held, correctly following the Evans line of cases, that it was a subject matter jurisdiction problem. So, I mean, there's no doubt.
Well, had it been raised earlier, you said it's jurisdiction, but couldn't the court just have applied Connecticut law and kept the case?
Your Honor, the court could have, but everyone was inadvertent to the subject matter.
So it wasn't jurisdictional just because North Carolina was raised at all. You could have said, wait a minute, Judge, we're raising this, it's Connecticut. If it was jurisdictional, then the court would have to just dismiss the case. Instead, the court said, oh, now we know the right law, let's apply Connecticut, correct?
Your Honor, not quite.
Why not?
Because the issue here is not choice of law on a freestanding issue. What is jurisdictional here is the effect of the state exclusive remedy statutes, and those have been recognized by this court as a problem of subject matter jurisdiction. There is a false conflict here. Nothing in our discussion or from my friend has cast any doubt on the point that the North Carolina and Connecticut statutes emanate from the same model act. They have the same exclusive remedies. If you compare section 995E and 996 of the Connecticut statute with sections 105 and 110 of the North Carolina statute, you're going to find effectively the same terms. That's why conflict of laws is not a real issue here, and conflict of laws is not a freestanding issue here because of its intimate connection with subject matter jurisdiction, as in Banks, as in Demetris. This is a hard situation where subject matter jurisdictional problem came up late, as in Capps, but the dictates of Rule 12H3 are clear. And again, we're the appellee here. The district court correctly recognized that. It correctly put the choice of law issue in its connection with subject matter jurisdiction. We'd ask that its decision be affirmed.
Thank you.
Thank you, Your Honor.
Thank you, Your Honors. Very briefly, the exclusive state remedies statutes and cases that AXA has just referenced are all workers' comp cases that have created by state law an exclusive administrative forum that deny any court, state or federal, jurisdiction over those disputes. This Connecticut statute, by turn, actually creates judicial remedies and contains exceptions, including an exception that we specifically pled in this complaint, that they passed along false information about Mr. Weiner with malice, such that even if one of these statutes were timely raised by AXA, Mr. Weiner had pled around that in the complaint and would have had an opportunity to challenge these affirmative defenses. This is a merits dispute, not a jurisdictional issue. There is no false conflict here. Mr. Weiner is not a North Carolina resident. That statute only applies to North Carolina residents. I would also note that this difference between the exclusive forum and an exclusive remedy in court is an important one. As the First and Second Circuit both pointed out in cases we cited, Violet and Sachs, building off the Supreme Court's ruling in International Longshoremen's versus Davis, that there is a difference here between an exclusive forum where no court has jurisdiction versus a statute that provides a judicial remedy, like the one that we're talking about here. AXA also tries to point out a difference at some level that I don't fully understand between waiver and forfeiture. Those cases are all based upon criminal law and criminal procedure. I'm sure that AXA is not taking the position that they can't waive an affirmative defense in a civil case that they never raised until after they lost a jury trial. This is exactly like the Valencia case, where this circuit found that choice of law is waivable if not raised in a timely fashion. For those reasons, unless the panel has any further questions, we would ask the court to reverse the district court's order on the motion to dismiss and reinstate the jury verdict in this case.
All right, thank you, counsel. Thank you all. Appreciate your being here. We can't greet you like we normally do, but know that very much we appreciate your arguments in this case, and we wish you well and be safe. Clerk will ask you to adjourn the court for today.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.